The third petition was E400 of 2020, Third Way Alliance Kenya versus Steering Committee of BBI and others. The substantive issue raised by the petitioner was whether a popular initiative for the amendment of the Constitution of Kenya can be commenced by state actors, in particular the President of the Republic of Kenya. The petitioner further argued that a popular initiative in the amendment of the Constitution cannot be commenced and undertaken without a legal framework for the same. The petitioner sought the following reliefs. A declaration that the Constitution of Kenya Amendment Bill 2020 was not a popular initiative towards the amendment of the Constitution of Kenya. B, a declaration that there is no legal framework to undertake an amendment by way of a popular initiative, to wit, collection of signatures and their verification and conduct of a referendum. And C, a declaration that county assemblies have the power to amend the amendment bill, do not have the power to amend the amendment bill. Number 4, petition E401 of 2020, 254 Hope versus the National Executive of the Republic of Kenya. The petitioner herein urged the court to determine whether the National Executive or any state organ or entities can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogola versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of delimitation of the constituencies is vested in the IEBC. They urged the court to declare as unconstitutional and annul the creation of the 70 constituencies in the amendment bill. The sixth petition was number E416 of 2020, Morara Omoke versus Raila Odinga and others. The petitioner raised the following issues. A, whether the Constitution of Kenya Amendment Bill 2020 can be submitted to county assemblies for consideration, tabled in Parliament for passing or rejection, and transmitted to a referendum in the absence of a legal framework for facilitating the same. B, whether the amendment bill can be transmitted to a referendum before a nationwide voter registration exercise. And C, whether the use of public funds by the President and Honorable Raila Odinga in the initiation and facilitation of the process culminating in the tabling of the amendment bill in Parliament is unconstitutional. And D, whether Parliament has power to act upon the amendment bill following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Alucher versus Uhuru Muigai Kenyatta and others. The substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the President in his personal capacity. And the last petition was number E427 was number 2 of 2021, Muslims for Human Rights, Muhuri versus Independent and Electoral Boundaries Commission, and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition, raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the Constitution, the provisions founded under Article 255(1) of the Constitution, forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution, and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution, would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose mode of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker of the National Assembly. He stated that the people of Kenya have the sovereign right to amend the Constitution in the manner prescribed under Articles 256 and 257 of the Constitution. On their part, the BBI Secretariat and Honorable Raila Odinga filed consolidated grounds of opposition, raising 10 grounds, most of which were a replica of the grounds raised by the first, second, and third respondents. They also filed an affidavit that was sworn by Mr. Dennis Waweru, who stated that he was one of the co-chairpersons of the BBI Secretariat, and its co-chairman was Honorable Junet Mohammed, that the Building Bridges Initiative was created and mandated with the task of initiating a constitutional amendment process and unifying Kenya among other functions. Mr. Waweru deposed that Article 1 of the Constitution of Kenya 2010 vests sovereign power to the people of Kenya, and such power is to be exercised only in accordance with the Constitution of Kenya 2010, that the Constitution is not a rigid document, and pursuant to Articles 255, 256, and 257, it can be amended as provided for in the said provisions, that if the framers of the Constitution did not intend that the Constitution be amended, nothing would have barred them from having such an express provision included therein. Regarding the doctrines and theories of basic structure, constitutional entrenchment clauses, and unamendable constitutional provisions as proposed by the petitioners, Mr. Waweru stated that they were mere theories and hypotheses only applicable in different jurisdictions and relevant depending on the special circumstances of each jurisdiction. The IEBC contended that in the exercise of its powers under Article 257, it enjoys constitutional and administrative, decisional, and financial independence, that it carried out its constitutional mandate of verifying that the constitutional amendment initiative was supported by at least 1 million registered voters, that it was erroneous for the petitioners to argue that there was no legal framework for verification of registered voters, as the provisions of Article 257 made it possible for the actors to know their obligations, and therefore there was no basis of making any finding against it. For making any finding against it. In respect of the petition by Mr. Isaac Alucher challenging capacity of the President to initiate a popular initiative for amendment of the Constitution, the President did not respond to the petition at all. However, the Attorney General filed grounds of objection, stating in the earlier that the President, Uhuru Muigai Kenyatta, cannot be sued in his personal capacity for any acts done during the pendency of his presidency, that the issue of constitutionality of the President's functions is res judicata, and that monies expended on the President's constitutional functions could only be audited by the Auditor General. The court could not be involved in such an issue. Having perused lengthy affidavits, written submissions, copious authorities, as well as oral submissions by counsel, the High Court made the following declarations. A, that the basic structure doctrine is applicable in Kenya. B, that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and eternity clauses. C, that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum. 2, a declaration is hereby made that civil court proceedings can be instituted against the President or a person performing the functions of the office of President during the tenure of office in respect of anything done or not done contrary to the Constitution. 3, a declaration is hereby made that the President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 4, a declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette on 10th of January 2020 is an unconstitutional and unlawful entity. Number 5, a declaration is hereby made that being an unconstitutional and unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. Number 5, number 6, a declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. Number 7, A declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. Number 8, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the steering committee on the implementation of the building bridges and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020 insofar as it proposed to have determined by delimitation the number of constituencies and apportionment within the counties is unconstitutional for want of public participation. Number 17, a declaration is hereby made that administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null and void because they were made without quorum, in the absence of legal authority and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the statutory. The IEBC, in its memorandum of appeal, raised 12 grounds of appeal, which I will summarize as hereunder. That the land
so-called to the Constitution relating to or touching on those matters can be done in accordance with Article 257, infused with the national values and principles. Whether a proposed amendment amounts to a dismemberment, abolition, or derogation of the Constitution is, as I have stated, ultimately a matter of judicial interpretation. Any other amendment to the Constitution that does not relate or touch to those matters can be made in accordance with 256. In my view, there are no eternity clauses in the Constitution. I then look at the scope of popular initiative and public participation, and I conclude as follows. Having considered the rival arguments on the remit of popular initiative and popular participation, the issues arising are whether an amendment of the Constitution by popular initiative is a preserve of the citizen, whether the President or the Executive can initiate amendment through the popular initiative, who was the promoter in this case, what is the scope of public participation in that regard. And I set out the provisions of Article 257, which I will not read. And I then say that on the face of those provisions, there is no qualification of who may or may not promote a popular initiative. As correctly submitted by counsel for the appellants, there is no explicit bar against any person, including the President, from promoting a constitutional amendment by popular initiative. It is not, as it were, in the black letter of Chapter 16 of the Constitution who may or may not propose an amendment. It is a matter of interpretation in accordance with the principles of constitutional interpretation to which reference has already been made. And then I go on and say, in the end, the framers of the Constitution separated the route which the elected representatives can take for amending the Constitution through parliamentary initiative under Article 256, and the route which the citizen can take through popular initiative under 257. Although the phrase popular initiative is not defined in the Constitution, the background I have set out above and the lexical meaning of the word popular lend credence to the conclusion reached by the High Court that the amendment by popular initiative under Article 257 is the preserve of the citizen. The concise Oxford English Dictionary, for example, the word popular is defined as including intended for or suited to the taste or means of the general public. Merriam-Webster Dictionary also defines the word popular to mean of or relating to the general public. In both definitions, the phrase general public features, and I do not think the President or the Executive would fall under the category of general public. In reaching this conclusion, I am cognizant of the provisions of Articles 19, 20, 22, 24, and 38 of the Constitution, and the contention that the holder of the office of the President, like every citizen, is entitled to enjoy rights under the Bill of Rights. However, it seems to me that the curtailment in certain respects of those rights in relation to the holder of the office of the President is sanctioned by the Constitution, given the constitutional role assigned to the holder of that office in the process. As to who the promoters with respect to the Constitution Amendment Bill is concerned, I will just summarize that and say, I take the view that the process began with a handshake, followed by the establishment by the President of the task force. Thereafter, the President established the BBI Steering Committee, whose mandate included proposing constitutional reforms. The BBI Steering Committee generated the Constitution Amendment Bill. The President and Honorable Raila Odinga then flagged off the signature collection. The Constitution Amendment Bill and the list of voters supporting was then delivered to IEBC by Honorable Mohammed and Honorable Aweru, the co-chairs of BBI National Secretariat. And I then say it is a continuous process, it is a continuum. It is unnecessary, in my view, to attempt to split that process to justify the claim that the process towards initiating the popular initiative began with the delivery of the draft amendment bill and supporting signatures to IBC, and to ignore what preceded that. The delivery of the draft bill and supporting signatures to IBC was part of a process that had begun before the generation of the draft amendment bill by the steering committee. In my view, all the players in that process, beginning with the President, Honorable Raila Odinga, the BBI Steering Committee, Honorable Mohammed, Honorable Waweru, qualify as promoters in a continuum that preceded the delivery of the bill. I do not think there is merit in the contention that the President's involvement in the amendment process was in his capacity as a private citizen. The material presented shows otherwise. The Kenya Gazette notices based on which the task force and steering committee, whose mandate, as I have mentioned, included consideration of proposals for amendment of the Constitution, are testament that the President was acting in an official capacity. And then regarding public participation, I have made reference to the guidelines that were given by the Supreme Court of Kenya in the British American tobacco case, and I have set those out. And then I have said that there can be no question, therefore, that public participation is a fundamental constitutional principle in our country, a major pillar and bedrock of our democracy and good governance, to quote the words of retired Chief Justice Mutunga in the matter of the National Land Commission. It is a constitutional command that it must be infused or integrated into the amendment process under Chapter 16. And then I set out other arguments, and then I conclude that I am therefore in agreement with the High Court that there is a legal requirement under Article 10 of the Constitution for voters to be supplied with adequate information to make informed decisions. There is no evidence that that was done in this case. I would not go as far as the High Court did in prescribing in minute detail how public participation might be undertaken. As the Supreme Court stated in British American tobacco case, allegation of lack of public participation must be considered within the peculiar circumstances of each case, and the mode, degree, scope, and extent of public participation is to be determined on a case-to-case basis. It is perhaps also a matter for the legislature to prescribe in appropriate legislation the scope and breadth of public participation, short of which the court is left to apply the standard of reasonableness on a case-to-case basis. To be clear, I take the view that amendment, properly so-called, of matters touching or relating to Article 255 is achievable through what the High Court referred to as secondary constituent power, namely public participation and referendum. And then I deal briefly with the issue of verification. And then I say as follows. Having considered the arguments, I take the following view. The role of IEBC upon delivery of the draft bill proposing amendment to the Constitution by popular initiative is set out in Article 257(4). In an affidavit sworn on 25th of February 2021, Michael Goa, a director of legal and public affairs of IEBC, deposed that IEBC received the draft amendment bill on 10th December 2010, accompanied by 4.4 million supporters' signatures, upon which it issued a press release on 18th December informing the public of the same. That IEBC carried out a process to confirm that the said initiative was supported by the signatures of at least 1 million registered voters in order to ensure compliance with the requirements of Article 257. That after completion of that process, an interim report was prepared during which data cleaning exercise by removing incomplete records, including missing signatures, ID numbers, names, duplicates, and those not in register. And that a list of verified supporters was uploaded on IEBC's website to enable them to check and confirm their details. That the purpose of uploading the list of verified supporters on the website was to provide an opportunity for objection by anyone who had been captured as a supporter without their consent. That upon completion of that process, it was established that the popular initiative met the constitutional threshold and the amendment bill was transmitted to the county assemblies. Based on the depositions in that affidavit, the finding by the High Court that the role of IEBC under Article 257(4) entails ascertaining the number of registered voters in support of a popular initiative to amend the Constitution and verifying that the initiative is indeed supported by the registered voters claimed to be in support is correct. As submitted by Council, the verification of signatures of supporters of the constitutional amendment initiatives entailed ascertainment of whether they were registered voters and had appended their signatures. The controversy appears to be with regard to precisely how IEBC was to execute or carry out the verification. According to IEBC, that would be achieved by posting the list of voters claimed to have supported the initiative on its website for scrutiny, with an invitation that any objections should be raised within a given period. The respondents, on the other hand, argue that IEBC should itself have undertaken a forensic examination. In the case of National Super Alliance versus IEBC, the court stated that courts cannot step in to police or prefect independent constitutional bodies or direct them how to carry out their own mandates, unless there is willful neglect or violation of their constitutional or statutory functions. And the independent commissions are clothed with discretion and latitude to decide the governance process or the procedure to employ as to how and when to execute their mandate, as long as it is within the law, and that this operational and functional independence has constitutional underpinning. So guided, the question is whether IEBC properly discharged its verification mandate under Article 257(4). The record shows that IEBC uploaded the list of signatories in support of the initiative on its website on 21st of January 2021. The closing date for scrutiny and for any objections to be taken was indicated to be Monday, 25th January. Under item Q and R of Part B on verification procedure of IEBC's administrative procedures, it states that after actual signature verification exercise and documentation, the compiled list of supporters is published in the Commission's website for information and verification for 2 weeks. Publishing the list of supporters over a weekend was clearly in violation of IEBC's own prescribed time frame of 2 weeks. The time provided for scrutiny and for raising objections was grossly insufficient. Why IEBC was in such a rush is not clear. Secondly, there is the question whether merely uploading the list on IEBC's website without more is sufficient. Would it have been more effective for IEBC to, in addition to uploading the list on its website, to publicize the matter in other media as well? These questions are germane and bolster the argument that a comprehensive legal or regulatory framework for the conduct of referendum is important. In my view, had the IEBC given sufficient notice, opportunity, and means to the public to interrogate the list of verified supporters of the initiative, it would perhaps have been considered to have been discharged its duty of ascertaining and verifying that the registered voters who had indicated as supporting had indeed done so. That said, the conclusion by the High Court that IEBC's role under 254 involved both ascertainment of numbers of registered voters in support of a popular initiative to amend the Constitution, as well as verification of the authenticity of those signatures, is partially correct in my view. Yes, IEBC is required to ascertain that the threshold of 1 million registered voters is met. Secondly, it must verify or establish or confirm that those voters whose names that have been submitted have in fact endorsed the initiative. That, as I have stated, is in my view achievable if IEBC affords reasonable means and opportunity for the voters to interrogate and confirm their endorsement of that initiative. That said, this discussion is further testimony of the need for legislative and regulatory framework for matters relating to Article 257. I then move on to look at the regulatory and legal framework, and I think I'll just go to the conclusion. And I say this: there is undoubtedly, therefore, some legal framework, albeit not an elaborate one, for the conduct of referendum, even though it may not specifically address or fully address all aspects of a referendum, including matters of collection, presentation, and verification under Article 257 of the Constitution. I do not doubt as I have mentioned, that it is important to have specifically tailored legislation that specifically and fully addresses matters relating to Article 257. Indeed, there is realization in that regard, as it was demonstrated that there are 2 pending bills before the National Assembly in that regard. That said, I agree with the High Court that notwithstanding the absence of an enabling legislation as regards the conduct of referendum, such constitutional process may still be undertaken as long as the constitutional expectations, values, and principles and objects are met, and that in doing so, the process must be in strict compliance with inter alia Article 10 of the Constitution, which prescribes the national values and principles, and that those principles must be infused at every stage of the process. That statement is consistent with the legal principle exemplified by a decision of this court in IABC versus National Super Alliance, where this court reversed a finding by the High Court invalidating procurement of ballot papers without legislative framework to facilitate a meaningful program of public participation. In doing so, this court expressed, and I quote, "The absence of a legal framework for public participation is not an excuse for a procuring entity or a state organ to fail to undertake public participation if required by the Constitution or law. A state organ or procuring entity is expected to give effect to constitutional principles relating to public participation in a manner that satisfies the values and principles of the Constitution." End of quote. Equally, the absence of a legal framework per se cannot be a basis for asserting that IABC should not discharge its constitutional mandate under Article 257. There is also the High Court decision in Titus Alila, where the question whether there was a proper legislative framework for holding a referendum arose, and the High Court found that the Constitution has already set up a proper legislative framework. In my view, therefore, the declaration by the High Court that the absence of a legislation or legal framework to govern the collection, presentation, and verification of signatures and other conduct of referenda renders the attempt to amend the Constitution through the Constitution of Kenya Amendment Bill flawed, even though qualified with a statement in the circumstances of this case, is one I am respectively unable to endorse. To the extent I construe it to mean that IBC cannot, absent specific legislation on conduct of referenda, conduct referendum under Article 257. There is then the matter of IABC's administrative procedures. And on that, I capture the arguments and then say that whereas the administrative practices were not avowedly made in exercise of the Commission's power under Section 31 of the Act, in a replying affidavit sworn by Michael Goa of IBC, he deposed that the administrative procedures were developed pursuant to Section 55 and Regulation 98 of the Election General Regulations 2012, after extensive public participation. Accordingly, based on Michael Goa's deposition, the administrative procedures fall within the statutory definition as they are made or established in execution of a power conferred by or under an act of Parliament, under which that statutory instrument or subsidiary legislation is expressly authorized. Moreover, this court can only interfere with the decision of the High Court if it is established that the High Court misdirected itself in law and that the decision is plainly wrong. On the matter of quorum, I say this. My view is as follows. Section 5.1 of the Independent Electoral and Boundaries Commission provides that the Commission shall consist of a chairperson and 6 other members, appointed in accordance with Article 254 of the Constitution and the provisions of the IBC Act. Section 5.3 provides that the process of replacement of a chairperson or member of the Commission shall commence at least 6 months before the lapse of the term of the chairperson or member of the Commission. Section 5.4 provides that the procedure set out in the first schedule shall apply with necessary modifications whenever there is a vacancy in the Commission. Section 7A of the IBC Act provides that the office of the chairperson or a member of the Commission shall become vacant if the holder dies, resigns from office, or is removed under circumstances specified in Article 251 and Chapter 6 of the Constitution. Under Section 7A(2) of the IBC Act, the President is required to publish a notice of vacancy in the Gazette within 7 days of the occurrence of such vacancy, and the process of recruitment, quote, shall commence immediately after the declaration of the vacancy by the President, end of quote. Section 8 of the Act provides that the conduct and regulation of the business and affairs of the Commission shall be as provided for in the second schedule, but subject thereto, the Commission may regulate its own procedure. Paragraph 5 to 7 of the second schedule, prior to amendments introduced through the Election Laws Amendment Act number 34 of 2017, provided, and I have reproduced those provisions there, I will not read them, and then I say that through Election Laws Amendment Act 34, paragraphs 5 and 7 of the second schedule are repealed and replaced with those provisions. Paragraph 8, which was not affected, of the second schedule, provided that subject to paragraph 5, no proceedings of the Commission shall be invalid by reason only of a vacancy among the members thereof. Those amendments were successfully challenged and declared unconstitutional by the High Court in Katiba Institute case, and I have cited passages from the judgment of Justice Muita, which are there. IBC contends that as paragraphs 5 and 7 as previously enacted had been repealed, the declaration by the High Court invalidating the amendments did not revive the repealed provisions. It was urged that by relying on provisions of paragraphs 5 and 7 of the second schedule, as they existed prior to the amending provisions being declared unconstitutional, the court relied on non-existent provisions, and therefore Article 250, which sets the minimum at 3, applied. Respectfully, I do not understand the decision of the Supreme Court in the case of Mary Wambui, which was cited as supporting the proposition put forth by IBC. If I understand the argument correctly, it is that the effect of the declaration of unconstitutionality by the High Court of the provisions of the Election Laws Amendment Act number 34 that had sought to amend paragraphs 5 and 7 of the schedule is that the schedule is now silent on quorum. That there is in effect no longer a provision and therefore recourse must be had to Article 250. I am not entirely persuaded by that argument. Article 250 of the Constitution does not, with respect, address the question of quorum of the Commission. It is a provision on composition. It sets the minimum number of persons who must make up the Commission. Quorum speaks to the minimum number of commissioners that must be present to make a binding decision. It speaks to the number of commissioners who, when duly assembled, are legally competent to transact the business of the Commission. As defined in Black's Law Dictionary, it is the minimum number of members who must be present for a deliberative assembly to legally transact business. Article 250 of the Constitution cannot therefore fill the gap which the IBC says was created by the declaration of unconstitutionality of the provisions that had sought to amend paragraphs 5 and 7 of the second schedule. In the case of Mary Wambui, the Supreme Court in paragraph 87 of the judgment expressed as follows: however, while we have pronounced ourselves on the issue of invalidity of section 76(1) of the Elections Act, in line with the Constitution, this court is not precluded from considering the application of the principles of retroactivity or proactivity on a case-to-case basis. I then look at the decisions they cited there, including the decision by Justice Kriegler in the South African case of Sears Moyes, and I then go on to say that the decision of the High Court in the case of Katiba Institute was silent on the effective date of the declaration of unconstitutionality. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum of 5 applies. I am therefore in agreement with the High Court that when it pronounced in the judgment that IBC Act categorically places the quorum of IEBC for purposes of transacting business at 5 commissioners, and that IEBC did not have that quorum at the time it made the consequential decision related to the Constitution of Kenya Amendment Bill. IEBC also contended that the impugned decision of the High Court runs afoul of a subsisting decision in rem in a constitutional matter, in the case of Isaiah B. Watt, which has been extensively cited. And I'll cut through and just say, I am conscious that this court is not presently sitting on appeal from the judgment of Isaiah B. Watt. However, it seems to me that quite apart from reading into the text of paragraph 5 of the schedule, the words policy decisions, and apart from mixing up composition with quorum, the learned judge appears to have either overlooked or infused statutory provisions with what she considered to be common sense when she stated, quote, "My take is that the issue of quorum, apart from being a matter provided for under the statute, is also a matter of common sense and construction, depending on the total number of commissioners." And then I have the rest of the passage, and then I say, further, in making that pronouncement, the learned judge does not appear to have considered the provisions of paragraph 8 of the second schedule, which provides, subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Under that provision, the requirement under paragraph 5 is overriding. The pronouncement by the judge in the above cited passage appears, therefore, to be an abrogation of a statutory provision, and to that extent is per incuriam. Consequently, the High Court in the present case was entitled, for that reason, among other reasons the court gave, to depart from it. Moreover, the statutory commands in the IEBC Act, if heeded and complied with, would have ensured that the number of commissioners would not have fallen below the number required to form a quorum. For those reasons, the complaint regarding the findings by the High Court as to quorum have no merit. I then move on to the issue of continuous voter registration, and I think I'll just say what I concluded. The High Court cannot therefore be faulted for having concluded, as it did, that there was no evidence that IEBC had discharged its obligation of continuous voter registration. I would therefore not interfere with the decision of the High Court. The last aspect I think I'll look at, separate and distinct referendum questions. On that I say, in my reading of those provisions, that is of the Constitution, it is the bill in which an amendment proposal is contained that is submitted to the people to vote on in the referendum by indicating whether they agree or disagree with the amendment proposal, much in the same way as the members of the county assemblies and members of the Houses of Parliament would have signified their approval or disapproval of the amendment process in the draft bill. It seems to me, therefore, that under Article 257(10) of the Constitution, as read with other provisions in that article, what is envisaged of the voter at the referendum is for the voter to make a choice to ratify or not to ratify, to approve or not to approve the amendment proposal in the draft bill. However, that choice, in my view, is rendered nugatory, inoperative, and consequential if the voter is called upon to vote on an omnibus draft bill that contains a raft of numerous, diverse, and unrelated proposed amendments to the Constitution, in this case over 70 proposals, that cut across the entire spectrum of the Constitution. And I cite the passage there from the High Court decision entitled Alila. The argument made for the respondents on the principle of unity of content or single subject matter, that constitutional amendment through a referendum should deal only with one main issue, is one I find most attractive and persuasive. It was argued that under that principle, the proposed amendment should deal with one subject only to allow the voter to form and express their opinion freely and genuinely. In other words, if a proposed constitutional amendment includes several substantive questions, the voter may not have a free choice, that each proposed constitutional amendment ought to secure adoption on its own merits, not on the merits of other different proposals to which it is attached. and that there must be an intrinsic connection between the various parts of each question to put to the vote in order to guarantee freedom of suffrage, and the voter must not be expected to accept or reject as a whole provisions without an intrinsic link between them. I would venture to suggest that what is envisaged under Article 257 is an amendment bill on single thematic topic to which the provisions in the draft bill must relate. For instance, a bill proposing amendments to the provisions on land under Part 1 of the Chapter 5 of the Constitution would, in my view, be entertained. Then I move on to constituency apportionment, and I think I have agreed with the lead judgment of the President, and so I will not deal with that. And then I deal with the matters touching on the President. Under this head, the issues are whether the President's right to fair hearing was violated, whether the President enjoys absolute immunity under the Constitution, whether the High Court was right in declaring that the occupier of the office of the President is liable to being sued in his personal capacity during his tenure of office. And I think I'll just go to the conclusions, which are as follows. Article 51 of the Constitution provides that every person has the right to have any dispute that can be resolved by application of law, decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal. Therein is the long-standing principle of natural justice that traces back to Ridge versus Baldwin, and also the case of Onyango, Olo Onyango versus Attorney General. I have also cited it there. The critical question, which is a matter of fact, is whether the President was firstly served with a petition 426 in which he was named as the first respondent, and secondly, whether he was served with notice of hearing. The record of proceedings of 21st of January 2021 show that the High Court gave directions on the conduct of the consolidated petitions. Among the directions given on 21st were directions that, quote, all the petitioners in the 7 petitions to serve the petitions on all the parties by close of business on 22nd of January 2021. The Deputy Registrar to facilitate the process where necessary, and that the respondents, interested parties, and amici to file and serve their responses to the various petitions within 14 days. On the same date, directions were given by the court regarding exchange of written submissions and the conduct of the hearing and hearing dates. The record shows that on subsequent appearances before the High Court, under the quorum in relation to petition 426 of 2020, the court always indicated no appearance for first respondent. The record does not show whether after the directions given on 22nd January 2021, any inquiry or follow-up was made by the court to confirm that his directions regarding service had been complied with. In subsequent attendances before the High Court, the record continued to reflect that there was no appearance for the first respondent, that is the President, in petition 426. The petitioner in 426, Isaac Aluocher, indicated on the face of the petition that it was to be served at the office of the President, Harambee House, Harambee Avenue, Nairobi. An email address was given, and telephone numbers, and a Twitter handle. Before this court, Mr. Aluocher filed a supplementary affidavit dated 8th June 2021, in which he attached an affidavit of service sworn on 16th of January 2021, in which he stated that he served the petition by email on all the parties, including the President, whom he served at the stated email address on 21st of December. He stated further that he also lodged a service request with the judiciary e-filing platform and got a response on 15th January, and that all parties had been served. Notwithstanding the directions given by the High Court on 21st of January, to which I have referred, it appears to me that the question whether the President was in fact served with a petition and the hearing notice in respect of the hearing appears to have been overlooked by the High Court. The continued indication in the record, no appearance for first respondent against the name of the President, after the directions given on 21st of January, should respectfully have signaled the court to inquire whether the President had in fact been served. The depositions by Mr. Aluocher in his affidavit sworn on 16th January 2021, filed in hearing, are matters that should have been presented before the High Court in order to satisfy itself that the President was duly served. In paragraph 537 of the judgment, the High Court observes that the President did not enter appearance in these proceedings, and neither did he file any grounds of objection or replying affidavit to contest these proceedings on the ground of misjoinder or any other ground. However, there is no indication that the High Court satisfied itself that service had been effected on. Indeed, in the same paragraph of the High Court judgment, the court stated, quote, "As much as the Honorable Attorney General has come to his defense, the grounds of objection and submissions filed by the Honorable Attorney General are clearly stated to have been filed on behalf of the Attorney General himself and not for Mr. Uhuru Muigai Kenyatta," end of quote. An acknowledgement, in my view, that the proceedings against the President were undefended. Having concluded that the Attorney General could not in this instance represent the President, it was imperative for the court to satisfy itself that the President had been served with the petition and the hearing notice. It is also noteworthy that although the High Court expressed in paragraph 532 of its judgment that the question whether the President can be sued in his personal capacity and not as the President of the Republic is a question that, quote, should be determined as a preliminary issue, quote, it was not in fact handled in that manner. For had it been handled in such manner, the determination should have been made before the substantive hearing of the petition commenced to afford the President an opportunity to defend himself in his personal capacity. By making the determination in the final judgment, that opportunity was lost. All in all, I am not persuaded that it was satisfactorily demonstrated that service on the President was effected, and for that reason alone, I would set aside the orders made by the High Court against the President in Petition 426 of 2020. On the presidential immunity question, I have indicated that I sat in the judgment of this court in Kenya Human Rights Commission and another versus Attorney General, and my views have not changed that the decision of the High Court is right in that regard. I still hold, therefore, and agree with the pronouncement by the High Court in the present case that the President can be sued in his personal capacity during his tenure because the protection afforded under Article 143(3) of the Constitution extends, quote, anything done or not done in the exercise of his power under the Constitution. On the issue of the amicus curiae, I have referred to the Supreme Court decision of Trusted Society of Human Rights and the extensive guidelines that were given there, and I have concluded that it was not demonstrated that the High Court exercised its discretion wrongly in admitting the amici. On the issue of justiciability, I have said that the matter was ripe and that it was not prudent for anybody to wait until the provisions became the Constitution and then have to contend with Article 2(3) of the Constitution, which prohibits any challenges to the Constitution. So with that, I will end it there and hand it over back to the President. Thank you.
Thank you very much, my brother Justice Gatembu. It is now 1:40. We shall adjourn for 1 hour. And so we will be back at 2:40. The court will adjourn. That the power to...
I have had the advantage of reading in draft the judgment of my learned brother, the Honorable Musinga, President of the Court, for which I am grateful. My Lord President has undertaken a thorough account of the pleadings and the procedural history of the petitions that were before the High Court, as well as of the consolidated appeals, together with the submissions made by the parties. I will thus not rehash much of what he has so helpfully delved into, and will only refer to some of the arguments made before us where necessary for contextual or illustrative purposes only. The themes I consider it necessary to pronounce and give my particular opinion on in various degrees of depth and breadth are the following: basic structure doctrine, popular initiative, jurisdictional objections, legality of BBI process, public participation, presidential immunity, legal regulatory framework for constitutional amendment by popular initiative, IEBC quorum, voter registration, format of the referendum question, constituency apportionment and delimitation, and then a comment or two on the cross appeals and on costs. Now, on the basic structure doctrine, of all the holdings of the High Court, none have come under furious and sustained attack by the appellants, aggrieved thereby, as those relating to the basic structure doctrine. Hours of argument were added to the thousands of pages of scholarly and judicial authority marshaled by opposing parties in an attempt to cast as blatant and mitigated error, or for their defenders, pure genius, the first of the learned judges' dispositive pronouncements on the doctrine. Supplementing their written submissions with eloquent and passionate addresses, the aggrieved appellants were categorical that the Triple Declaration amounted to a rewriting of our Constitution and was wholly antithetical to settled jurisprudence, both local and regional, which to their mind wholly repudiates and rejects the applicability of this strange doctrine from foreign jurisdictions far removed from our particular circumstances. In his opening address, the learned Solicitor General, Mr. Kennedy Ogeto, took the view that the Constitution has no place for the doctrine and all its provisions are amendable in accordance with clearly set out procedures for various aspects of it. The Constitution has no eternity clauses, and Kenyans consciously avoided the basic structure by making no mention of it. They struck a proper balance between hyperamendability and rigidity by including Chapter 16, which entrenched provisions with special amendment procedures. That theme was taken up by Mr. Oraro, learned senior counsel, who posited that unamendable or eternity clauses cannot be recognized unless they are stated expressly in the Constitution. When pressed to point out where the doctrine was rejected, where exactly it was rejected in the report by the committee of experts, he responded, apparently without irony, that entrenchment was implicitly rejected. Answering another question about Colombia, he said that Colombian case was an outlier and it is a divided country and we should not follow its example by acknowledging an implicit existence of a basic structure and an amendability in our own Constitution. He next made the submission that the case at bar was the first time the basic structure doctrine was applied in our jurisdiction. It had been adopted by the Indian Supreme Court in the Kesavananda Bharati versus State of Kerala and another way back in 1973 in India. And even though it was accepted in Bangladesh, Council's view was that it has been rejected elsewhere and it is inconceivable that we can introduce it in Kenya. Mr. Oraro was emphatic that our Constitution provides for its alteration and that as such the people can make any amendment they deign, including, should they so desire, an amendment to abolish Parliament. That being the case, it is not open for judges to unilaterally come up with standards not provided for in the Constitution, thereby raising the bar of amendability. He fervently lamented that the High Court, quote, wants us to be subject to an academic doctrine invented by the Indian Supreme Court, end of quote. Also opposed to that doctrine was Senior Counsel Mr. Orengo, whose opening salvo was that it presupposed that the people as sovereign do exist without or outside the Constitution, which he considered to be fallacious. He was rather dismissive of the learned judges, charging that, quote, they were so anxious to apply the basic structure doctrine that they invented it, end of quote, which he termed, quote, a trip to Wonderland, end of quote. Moreover, he said, the learned judges were accused of being merely ideological and failed to notice that even the Indian judges were not agreed on what constitutes basic structure, and he therefore asserted that every article of the Constitution is amendable so long as it is done constitutionally. That narrative was taken up by Mr. Mwangi, learned counsel for the BBI Secretariat, and the Right Honorable Amolo Odinga. Such analysis, according to counsel, was deliberately undertaken with the aim, that's the historical analysis, with the aim of justifying the basic structure doctrine, and he took issue with the fact that the judges quoted articles by Yashpal Ghai and Jill Cottrell, Alicia Vernon, and James Gadhi, and made scant mention of the report on the Constitution of Kenya Review Commission, of the Commission, which is the official history of constitution making. He sought to distinguish the Kesavananda case, which he stated has a dark past, as posited in the book The Indian Supreme Court and Politics. On the whole, counsel was derisive of the unamendability doctrine as, quote, the product of New Age scholars, end of quote, whose concepts, quote, are not employed elsewhere in Africa, end of quote. And he urged us to follow the example of Uganda, which rejected it and ruled what he saw as foreign ideas being tried on us. Turning to theology, he pleaded that to accept the notion that certain parts of the Constitution cannot be changed would amount to idolatry, under which we would have hoisted the Constitution to a position that is higher than man, and thereby will have made ourselves servants, yet the law is made for man, not the other way around. He urged caution lest the spirit of the Constitution should create a legal theology. Dr. Otienda Amolo, senior counsel, also took that view, but seeming to make so slight a concession that the doctrine does apply, learned senior counsel asserted that even then, the learned judges treated it as in a wholly unsatisfactory manner that left it in, according to him, utter confusion. Even though the IBC, whom he represents, did not directly appeal against the basic structure doctrine, learned senior counsel Professor Githu Muigai still made submissions germane to the issue. He made the bold assertion that the 2010 Constitution did not rewrite the foundations of the law of Kenya, which remain the same as they have been since 1897. He then complained that the learned judges adopted an approach that supports the view that nowadays all political, social, and economic grievances are being taken before the court, yet the High Court has limited jurisdiction to entertain constitutional grievances where a clear cause of action exists and brought by people who have standing. To entertain such grievances and make such orders at large leads to an erosion of the dignity and sanctity of the court, and then he asserted that 9 out of 10 of the learned judges' orders are opinions born of their acceptance of an invitation to act as a philosophical tribunal. Mr. Kuyon, the learned counsel for the National Assembly, also urged rejection of the doctrine, but in the present case he considered, as he had to, that 74 amendments proposed in the BBI bill were numerous. He nonetheless invited us to reject the doctrine unless we should find that there is a threat of hyper-amendment of the Constitution. For the Senate, Mr. Learned Counsel, Mr. Job Wambulwa, was also against the doctrine. He urged us not to follow Indian jurisprudence on the subject, given the fundamental textual and contextual differences between our constitutions, with the Indian one reposing amendment powers with Parliament by a simple majority. For the county of Kiambu, Ms. Njoki Mboshe, who, in support of the appeal, declared that nobody can legally, by eternity clauses, oust Wanjiku's sovereign right to self-determination, went on to emphasize that the basic structure has no place in Articles 255 and 257 of the Constitution. She urged us to exercise abundant caution in borrowing foreign jurisprudence. For the County Assembly of Kirinyaga Land Council, Mr. Ndegwa Njiru was equally opposed to the doctrine, and returning, he made reference to the Kivuitu, Priscilla Ndululu Kivuitu and another versus the Attorney General, and he said that he considered that the court there did recognize the basic structure doctrine, but added that once the people were involved through a referendum, it was within their rights to alter the basic structure. Mr. George Albert, Land Council, was of the view that Kenyans chose 10 articles to protect from amendment by requiring that they be subject to a referendum. And according to him, the terms basic structure, eternity clauses, and unamendable clauses are used interchangeably. Against those attacks on the learned judge's acceptance and endorsement of the basic structure doctrine was an equally eloquent and impassioned battery of counsel. Mr. Harvey, appearing with Ms. Angawa as Land Counsel for the first to fifth respondents, extolled the 2010 Constitution as a perfect charter. He took grave issue with the BBI proponents who proposed, according to him, 74 amendments by a single stroke of the pen, thereby dwarfing the 38 amendments to the independent constitution carried out between the years 1963 and 1991. He was emphatic that the doctrine of unamendability and basic structure actually is implicit, and that changes to that core structure can only be effected through the exercise of constituent power with four features, namely civic education, public participation, debate, and referendum. He was quick to add that the constituent power is not textualized in the Constitution, but is definitely applicable, and he placed reliance on the judgment by Justice Ringera in the Njoya case. Pointing out that the constituent power did not originate with the Ringera J, counsel made reference to John Locke's two treatises of government and Baron de Montesquieu's The Spirit of the Laws, to assert that it is neither emergent nor alien, as it is rooted in antiquity as a feature of democratic governance. Pointing out that the basic structure is already part of the Kenyan jurisprudence, having made its first entry with the Njoya decision, he asserted that there are limits to amendability. Citing Nwabweze and referring to the preamble to the Constitution, he urged that the Constitution is indeed intended to endure for ages to come. It thus did not matter whether or not the basic structure was textualized as such, and he called in aid other doctrines such as the separation of powers, checks and balances, independence of the judiciary, etc., which, though not spelled out in the constitutional text, are nonetheless an integral part of the Constitution. Asserting that a strict scheme of amendment did not justify repeal of the Constitution, and that the two are in fact dichotomous, Mr. Harvey made an appeal to history, stating that amendment powers had led to effective repeal of the independence Constitution. He pointed out that Justice Ringera had acknowledged that, but mentioned that there was no challenge to those amendments. Such fate should not befall the 2010 Constitution on account of the, quote, according to him, fortunate, successful challenge mounted by his clients against the 74 proposed eviscerations of our permanent charter, end of quote. Citing the writings of various jurists, including Professors Richard Albert and Yaniv Rosnai, counsel warned of the dangers of populist constitutionalism characterized by constitutional capture. He also referred to Dr. Mutaha Kangu's Constitutional Law of Kenya on Devolution, in which he accepts the basic structure as applicable in Kenya. To him, the BBI proposed amendments destroy, eviscerate, and dismember the Constitution's basic structure by creating an impure presidential and parliamentary system, domiciling the cabinet in the legislature, thereby obfuscating legislative and executive functions, contrary to separation of powers, and interfering with judicial independence by creating and installing what he called an executive prefect over it in the name of an ombudsman. Mr. Mutuma, counsel, argued in favor of the doctrine, adding that courts bear more than obligation to defend the Constitution as they are invested with the authority to defend it. He made a distinction between amendment and repeal by making reference to Black's Law Dictionary. So stating, he posited that the BBA initiative and Constitution Amendment Bill was an attempt to repeal the 2010 Constitution by implication. This is impermissible because the said Constitution is for eternity, which he explained to mean, quote, for as long as we have it. Next came Professor Kidure Kindiki Learned Counsel, who posited that there is a hierarchy of constitutional norms. And to demonstrate the basic structure, he posed the question whether one can amend the Constitution to change Kenya from a multi-party democracy into a constitutional monarchy, or alter its territory by having a part of it donated to another state, as had happened elsewhere in history. To him, such fundamental changes require a direct involvement of the people. He went on to say that the judges did not say that the basic structure cannot be altered, as the complaining appellant seemed to project, but rather that such changes must be subject to a deeper process involving the sovereignty of the people. He went on, indeed, appealing to us to dismiss the appeals with costs. He turned all spiritual, submitting that the BBI process was a botched attempt to overthrow the people and the Constitution, but, quote, by the mercy of Almighty God, the High Court intervened and declared it a nullity. Next came Dr. Mudhomi Thiakolu, who invited us to consider a quartet of questions. What kind of precedent do we want to create? What incentives for constitutional compliance will we put in place? How will future presidents treat the Constitution should we lend to this, according to him, illegality, judicial imprimatur? And how will politicians behave in the future? Resorting to Greek mythology, counsel implored us to recall the Hydra of Lerna, that multi-headed sea monster, which he likened to the impunity that has stalked this land, and urged the judiciary to be as steady as the sword as was the hero Heracles, and so slay it by upholding the judgment of the High Court. Learned Senior Counsel Dr. Kaminwa was categorical that the 2010 Constitution came about in answer to our rotten past and in response to global jurisprudence. Quoting from various books, he said that the 2010 Constitution was Kenya's way to sending a never again message to all that had gone wrong with us before. He declared that the Constitution is unamendable by the methods proposed in the BBI initiative and bill. The basic structure is not confined to India, but has spread worldwide. It was categorical that the problem in this country is not with the Constitution, but with ourselves, and especially with the politicians, quote, most of whom are mere job seekers who stand for absolutely nothing, end of quote. He urged us to throw out this appeal as unmeritorious. Equally scathing was Ms. Martha Karua, Learned Senior Counsel, who appeared for the professors of law who had been admitted as amici curiae before the High Court, positing that constitutions exist to limit the excess of authority. He lamented that in Kenya, the executive, state entities, and state officers ignore the fact. Stating that under Article 165, the courts can make determinations whether anything done is constitutional, he pleaded with us to hold that the Constitution is yet to be fully implemented as the final word on its interpretation. She asked us to mark the beacons for excesses of power by the executive and to, quote, uphold and protect the basic structure which is part of the DNA of the Constitution, end of quote. She was joined by Ms. Nyanguto, Land Council, who argued that the basic structure is inherent in the Constitution and urged us to uphold it and thus protect the Constitution from the BBI bill, which, quote, portends the death of the 2010 Constitution by 1,000 deadly cuts, end of quote. Coming next, Learned Counsel, Mr. Zebedeo Ongoya, argued that the judges did not merely import the doctrine from India, from Indian case law, but rather found it in the history, text, and structure of the Constitution. In doing so, they developed a rich indigenous jurisprudence in a manner that was praiseworthy and not objectionable to deserve the attacks directed at them. He made reference to the decision of Lenaola J, which has been referred to in the Commission for the Implementation of the Constitution versus National Assembly. He went on to say that the learned judges were correct to delineate three types of sovereign power, namely primary constituent power, secondary constituent power, and constituted power germane to a determination of the questions at bar. This same theme was echoed by Learned Counsel Mr. Evans Ogada, who submitted that when the judges pronounced themselves on the basic structure doctrine, they were declaring a legitimate reality and were not merely engaging in lofty theory. Learned Counsel Mr. Ochel Dudley distilled three strange positions, according to him, that this court would have to simultaneously adopt in order for it to overturn the learned judges' findings on basic structure. Those three are: one, we would have to adopt textualism, we would have to elevate the political elite above the people, and finally, we would have to upset a settled theory of constitutional change. Referring to the case of Kesavananda, he indicated that our position is no less perilous than that faced the Indian courts, because we have 74 missiles that are trained at our constitution. To him, changing the constitution is not a normal state function, but an extraordinary authority. He pointed out that the power to amend is not authority to annihilate the constitution, which he warned could easily be abrogated by gradual amendments. He referred to the writings of Hans Kelsen to assert that the constitution is the Grun norm. It has to be accorded a more stable character. Thus, it is not enough for those intent on altering the constitution to just marshal the numbers, recalling that such formally compliant machinations have happened before. Learned Counsel Mr. Madenge took the view that the text of the 2010 Constitution in fact supports the basic structure doctrine, because the Constitution has a core content and contains fundamental prior principles that are immutable in character. Making reply to all that, Mr. Nyamodi contended that the basic structure and the basic structure doctrine are not synonymous. The former refers to fundamental entrenched provisions which the Constitution contains, while the latter restricts amendability of the Constitution, a notion he rejects, as all provisions, according to him, are amendable, albeit by use of a different procedure where entrenched provisions are concerned. Finally, he conceded that Professor Rosnai is undoubtedly an authority on the basic structure doctrine, but invited us to find that the intensity of judicial review of proposed amendments depends on the amendment process involved. Mr. Donald Kipkorir, Learned Counsel, maintained that the basic structure doctrine was inapplicable in Kenya. And he seemed to suggest that it would be archaic and anachronistic to insist on a phenomenon from classical Greece where constituent power was exercised directly. Professor Muigai, Senior Counsel, in reply, labeled this a case about theory and not a live one about live people. He repudiated the idea that a constituent assembly is any more effective an exercise of power and authority than the people's exercise of sovereign power to effect or ratify radical changes to the Constitution at a referendum. He urged that the BBI Amendment Bill was not trying to reenact the Constitution because it left 90% of it intact. I have taken the trouble to set out only the oral submissions made on this fundamental issue of great significance, even though I have painstakingly read and pondered over the copious written submissions filed, as well as the numerous authorities cited. Before I go into a detailed analysis of the arguments, I'm skipping quite a bit because of time. Before I go into a detailed analysis of the arguments, and specifically the case law and academic writings presented to support the rival positions, I must confess that hearing the positions taken by some of the parties before us had an air of the surreal about them. Some counsel spoke of the basic structure doctrine as if it was a novel and unheard of idea that had just set foot on our jurisprudential shores for the very first time. It was projected as a thing of pure theory, a hypothetical chimera, never before applied to real situations. Moreover, the manner in which this country's long and painful search for a new constitution was projected by opposing parties left me wondering whether we had facts and alternative facts. Well, I will refrain from drawing any inference that any of the learned counsel before us were out to mislead the court, at least at this point, and give it the most charitable interpretation that texts sometimes speak differently to different readers. But counsel should nevertheless endeavor to apply their best mind to extract the true meaning of the constitutional text, as well as the judgments and academic writings on a subject. Only then can they be truly said to have assisted the court and shown themselves honest guides as required of advocacy at the bar. I do not consider it necessary to go into do a detailed history of the making of the 2010 Constitution. Suffice it to say that its promulgation, which is seen as the birth of the Second Republic, was the culmination of many years of struggle and pain, sweat and tears, in which liberty, limb, and life were harmed and lost so that Kenyans could have a better life of freedom and dignity, and in particular, that they could have a government that is answerable to them and leaders who serve them, not lord it over them. The Constitution is a charter of liberty, the embodiment of a new deal, and a break from a past characterized by oppression and suppression of freedoms as simple and essential as expression, association, and assembly. The one-party state, first de facto, and then by the instrumentality of the rushed amendment that brought in the infamous Section 2A of the retired Constitution, installing the Kenya African National Union as the sole political party de jure, brooked no opposition. Treason, sedition, public order, foreign exchange restrictions, and a motley other laws were used to beat the populace into submission. Detention without trial, torture, prosecutions on trumped-up charges, confiscation of passports, and many other misdeeds marked the darkest days of independent Kenya. The spirit of our nation is a resilient one, however, and buoyed by and inspired by happenings elsewhere, including the collapse of the Berlin Wall and the reforms occurring in the former Soviet Union through the policies of glasnost and perestroika, there was sustained agitation for more democratic space. In time, Section 2A was repealed, reintroducing multipartism, and through false starts and faltering steps, the new constitution was born. It was the product of phenomenal public participation and driven by bold Kenyans represented as the ordinary Wanjiku, who might as well have been Auma, Amina, Chela, Mwende, or Mora, and all of their male equivalents. Kenyans gave their views on what ailed their land and their institutions of governmental power. Their cry was for a more equitable share of resources, and ensure that their voices were heard before they declared in a detailed preamble that they were, among other things, honoring those who heroically struggled to bring freedom and justice, proud of our diversity, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of government of our country, and having participated fully in the making of the Constitution. To my mind, this preamble provides the context and setting the background and canvas against which an analysis or interpretation of the Constitution must be undertaken. The Constitution was not the product of an immaculate conception. Rather, it was the product of a rich experiential milieu of legal, social, and political interaction, more particularly captured in numerous historical accounts of trial and ultimate triumph, including the final reports of the Constitution Review Committee and the Committee of Experts. Any court interpreting the Constitution must perforce be alive to the historical background if it is to do justice to the text of the Constitution. Anything short of that would be drab, dry, and skeletal at best, lacking the pulsating animation of a living document possessed of a spirit and an ethos. Indeed, as if fully aware of the easy slide to dry formalism in construction, an obsession with text and lexical renderings, oblivious to history and context, the Constitution itself provided the keys to its construction in explicit terms in Article 251(1), which is that it must be interpreted in a manner that promotes its purposes, values, and principles, that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, that contributes to good governance, and every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. It seems to me plain beyond argument that fealty to the constitutional text itself throws open the pathways of interpretation to the end that one must look at what the Constitution provides in a manner that is wide and imaginative, so that it should be given the fullest amplitude of meaning and intent. The interpreter must have the purposes, values, and principles of the Constitution ever in mind as he undertakes the task. What is called for is purposive, value-laden, and principled approach to constitutional interpretation, as opposed to a narrow, neutral, and ultimately neutered formalism. Moreover, those charged with interpreting and giving effect to the Constitution cannot shut their eyes to, or be indifferent to, or worse, evince a hostility towards the rule of law, human rights, and fundamental freedoms. The Constitution commands judges to be active participants in those causes, and it behoves us to constantly introspect and deliberately push forward the rule of law and the human rights project. It would be a serious dereliction of duty, productive of deleterious effects, were those charged with the solemn duty of advancing these causes to be found wanting through carelessness or inattention, thereby either stalling or reversing them. To me, stringent urgings for judicial restraint where the rule of law is under threat and human rights are abused are totally antithetical and anathema to the plain constitutional interdict. Where these matters are concerned, fealty to the judicial oath demands, nay, commands, conscious activism. We do not become judges to subvert the plain and uncompromising edict to advance the rule of law and human rights. To my mind, that the Constitution very deliberately calls me to be a warrior for the rule of law and human rights, and to be both faithful and fearless in the cause is beyond question. Precisely because the law, as with life, is not static, the Constitution calls upon those who interpret it to do so in a manner that permits the development of the law. This is an acknowledgement that our knowledge of law is not at its zenith, and none can boast of having attained the acme of legal omniscience. This is where we are called upon to be open-minded, even to those concepts that may at first blush seem strange or challenge our long-held beliefs. We live in a globalized world, and courts will always be part of a continuing conversation on comparative constitutional law and practice. We are part of a global community of courts, and we definitely can and do benefit from a cross-pollination of ideas. We receive and consider those that have migrated to us, being careful to accept and incorporate those that can be said to be markers of positive development, even as we should think that our own progressive jurisprudence is solid enough and sufficiently persuasive to other jurisdictions. That, to me, is the constitutionally ordained interpretative prism and lens through which I must approach and decide the applicability of the basic structure doctrine to our Constitution. I proceed from the appreciation that the Constitution is laden with normative fecundity, which should vivify all persons who are charged with its application or interpretation. I've mentioned some provisions, and I say those provisions are couched in plain and peremptory terms, requiring no further exposition. I need only state that the obvious fact that this obligation, unquestionably binding as it stands, takes on a more solemn aspect, sacred even, in the case of those who occupy certain state offices by first swearing allegiance to the Constitution. Such oaths are of the gravest import and not to be lightly taken or regarded as mere formal incantations, empty rituals bereft of meaning or substance, to be violated with no consequence. Those who swear by the Constitution must be prepared to live by it and defend it as commanded, or else give the officers that come with such burdensome demands on their loyalties and consciences a wide berth. It should be plain by now that the approach to constitutional interpretation that persuades, indeed binds me, is a purposive and holistic one, which repudiates the text as the alpha and omega on the divination of the meaning and intent of the Constitution. One needs only cast a glance at our history of constitutional jurisprudence to see the long shadow cast by a textualist obsession as exemplified in Republic versus Elman back in 1969. That approach, thankfully long interred, although every once in a while we hear its ghost clanging its chains, seeking a place at the interpretative table, declared that the Constitution was to be interpreted in the same way as any other statute and frowned upon any resort to the spirit of the Constitution in derisive and almost epithetical terms. The fortunes of Elman doctrine have been traced in Mudhomi Ntiankolu's Landmarks from Elman to the Saitoti ruling, searching for a philosophy of constitutional interpretation in Kenya. It is no wonder that for long periods of Kenya's post-independence history, constitutional guarantees of freedom and fundamental rights remained for the large part, mere pious platitudes. And I see this as an object lesson for those of us on whom falls the obligation to give meaning to what the Constitution provides. We must learn from the mistakes of history, lest we be doomed to repeat them. It only takes a restrictive, minimalist interpretation here and a textualist, formalist approach there for the spirit of the Constitution to be stymied and its lofty ideals to hemorrhage towards barrenness by a drip drop of near imperceptible clawbacks and innocuous seeming small steps of mark time, slide, and reverse. And I need only add that the Supreme Court has recognized that the 2010 Constitution is a transformative charter to be understood and interpreted as such. In much the same way as new wine cannot be stored in old wineskins, it would be totally illogical to try and squeeze a transformative constitution within the suffocating straitjacket strictures of formalistic or positivistic interpretation. I have no difficulty whatsoever following the fresh and expansive interpretive path blazed for us by the Apex Court in several pronouncements. I've quoted them. I've quoted the Supreme Court in the Interim Independent Electoral Commission case. And then in the matter of the Speaker of the Senate, the Supreme Court characterized the 2010 Constitution as having gone beyond the usual parameters of liberal constitutions with its deliberate aim of attaining social change and reform as spelled out in the preamble, part of which I have already adverted to. The aim of that transformative approach is to recognize and reset the interplay of majoritarian and non-majoritarian institutions of the state so as to reach the desired governance goals. It is not difficult to see that such a constitution can ill afford a mean-spirited and narrow-minded interpretive approach as that would totally negate and defeat its transformative aims of facilitating the socio-economic and political growth of the country. This is identified in the Supreme Court Act, but flows from the Constitution itself and must guide all courts in interpreting the Constitution. I have agreed with the words of Chief Justice Emeritus Mutunga in the Speaker of the Senate and another versus the Attorney General. Only to take perhaps one sentence from there, it is in this context that the spirit of the Constitution has to be invoked by the court as the searchlight for legal illumination and elimination of these legal penumbras. From my analysis of their judgment, the learned judges were faithful to an interpretative scheme that was holistic, cognizant of the transformative character of the 20th century Constitution, purposive, and properly contextual. That approach accords with my own understanding of what the mental orientation of a court undertaking interpretation of our Constitution ought to be, and I would accordingly reject the criticism leveled against the learned judges. I do not accept the attempted denigration of their acknowledgement of the spirit of the Constitution, as if recognition of the spirit of the Constitution was some spiritist, animist retreat to a dark and ignorant or superstitious past. To the contrary, every legal instrument does have a spirit and soul that animates it. The learned authors of Black's Law Dictionary, 11th edition, trace it back to 1802, more than 2 centuries ago, and explain that it is also termed as the spirit of the law and means, quote, the putative intention of the creator or creators of a legal instrument, as opposed to its literal content. This is to be contradistinguished from the letter of the law. And they also treat of the spirit of a letter conception, which is of much recent birth, born in 2014, which they define as, quote, the notion that the spirit of the legal text should prevail over the letter. As far as the spirit of the Constitution is concerned, we endorsed it in the case of the Independent Electoral Boundaries Commission versus Mena Kia and others way back in 2017, where among other things we said the constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the interim independent electoral commission. We dare say that in the context of the Constitution there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs of more than 20 pages of history. I do not wish to repeat that history. I've already given I've given a brief overview of the same, but some of the marks of it, some of the high points or low points include the CKRC draft constitution, the general, the post-election violence of 07, Agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values that enjoy transcendental existence, whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentalities for the formal adoption of a document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwana vandima mire makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and all but obliterate the promise of freedom for the citizens and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present constitution, the past constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence than the power elites embarked on diluting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances, and a concentration of power in the presidency. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5 to the office of the president and starts off under the head the extent and reality of presidential power by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation of the reality that informed Kenya's search for a new constitutional paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, he talks about aggregation of power, concentration, etc. So, that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions, the very next year by the Constitution Repeal of Restrictions Act of 1958, which was passed strictly in accordance with the prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. The proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of deja vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Nobweze then recounts the Kenyan experience under which the provisions relating to entrenchment and thus restriction of amendment power were systematically removed or watered down. I believe this particular part was also quoted by my learned brother, Mr. Justice Gatembu. I will not go over it again. After detailing the same trend in Uganda, Tanzania, Malawi, and Zambia, the author observed quite correctly, in my view, that whereas amendments per se may not be objectionable, quote, too frequent amendments may tend to reduce the Constitution to the level of an ordinary law, depriving it of any claim to respectability and devotion, which might in time earn for it a status akin to sanctity. Kenyans were keen to ensure that the 2010 Constitution did not suffer the same ignominious fate as its predecessors, and they told the CKRC that its amendment had to be restricted. And I have quoted the report on what the people said and the commentary by CKRC, where indeed they concluded the people therefore wanted a fairly rigid arrangement, the amendment of which would require their participation in some form. In their view, the new constitution should only be amended in the same way in which it is made. I have laid emphasis on the last part of the commentary because, to my mind, the people of Kenya were quite clear that they were not going to cede the constitution to the vicissitudes and vagaries of political expediency. Having birthed it, they were prepared to nurture it and protect it from mutilation or dismemberment. They desired to be involved in its fate and fortune, and were essentially saying that only as they made it could it be substantively altered with their full and informed participation. It is clear to see, therefore, that the people, as creators of the Constitution, were exercising a power that was without and above the Constitution. They could not have been creating it pursuant to any of its provisions for the rather commonsensical reason that it was not existing at the time, not having been constituted. The power to constitute a constitution predates the Constitution, and it is, with great respect, quite absurd to seek constituent power within the Constitution. The power is original, a priori, primordial, and is inherent in the sovereignty of the people. It is not subject to the Constitution, which is but an emanation of it. This is the constituent power with which the people themselves, acting directly, can both make and replace a constitution. I've quoted Nobweze. The Njoya decision, which Ringera actually quotes Nobweze, was never appealed against and has remained the law on this subject, followed and reaffirmed on many occasions over the last 15 years. I have gone over Ringera's judgment, Ringera J's ruminations on the subject of constituent power, its being an expression of the sovereignty of the people, its existence outside the Constitution, yet having implicit recognition in it with a cognizable juridical status. Having done so, I think I can do no better than set out at some length what he had to say, with which I fully concur and apply mutatis mutandis to the 2010 Constitution, but because of time, I will not read all of this stuff that he said. The relevance of the constituent power to a discussion of the basic structure doctrine is that it is presented as the only authority that can effect a legitimate alteration to an aspect of the Constitution that lies at its core or relates to its essential character. The argument is that amendments or alterations of that kind are not amendments properly so called, but have the effect of abrogating it or destroying the very foundations or pillars upon which it rests. I've quoted John Rawls in Political Liberalism, where he says, he gives an example of whether the Americans could decide and amend the first Constitution, the First Amendment, and replace it with an opposite fundamentally contradicting principle, such as establishing a state religion. Such a move would amount to a constitutional breakdown or revolution in the proper sense, and not a valid amendment of the Constitution. Professor Robert Albert, in an article called Constitutional Amendment and Dismemberment in the Yale University Law Journal of International Law, states that this Rawlsian view reflects the conventional understanding in the field of constitutional change. Either a constitution is amended consistently with the Constitution, or the alteration is so transformative that we cannot call it an amendment, and we must instead recognize that conceptually it creates a new constitution. Under that view, this would be the case even if the old constitution is not formally replaced with a new one. It can safely be argued that any amendment that alters the core aspects of a constitution, changing its character and ethos in a radical manner, is essentially changing its basic structure, and in all but word abrogates or dismembers the Constitution. The basic structure doctrine and the notion of constitutional dismemberment have the same effect of positing that such constitutional amendments are in fact unconstitutional. I've quoted the concurring opinion of Mr. Justice H.R. Khanna in Kesavananda. And I just want to mention that it's important to note that the Indian Constitution, just like ours, did not then and does not now contain unamendable provisions in its text. It lacks express limitations to its amendability. This is in contrast to some other jurisdictions in which the constitutions contain provisions prohibiting amendment of certain subjects, leading to the terminology, as Professor Raznai notes in his PhD thesis, the terminology of immutable, unalterable, irrevocable, perpetual, or eternal, all of which he considers, and I readily agree with him, to be inaccurate. Why? Because they imply everlasting provisions, but they are neither eternal nor unchangeable. While they serve as a mechanism for limiting the amendment power, they do not and cannot limit the primary constituent power. Moreover, their content can also change through judicial interpretation. The Brazilian terminology, which refers to these provisions as Petraeus clauses, which I understand, that's me, which I understand to mean founded on rock. Petraeus clauses, to express their rigidity, is more accurate in that respect, since even rocks cannot withstand the volcanic outbursts of the primary constituent power. Therefore, in order to describe the legal situation more accurately, I refer to these provisions throughout this thesis as unamendable, as opposed to eternal or eternity clauses. The scholar notes that the technique of expressing prohibiting the amendment of certain state features, be they the form of government, separation of powers, or the like, spread like a fire in a thistle field, or, if you like, in the Gikomba clothes market, and was impelled in part to protect the Constitution by guarding against what he calls popular levity and legislative caprice. He then concluded that just as having a form of constitution virtually became a symbol of modernism following the American and French Revolution, so too nowadays having an unamendable provision is becoming a universal fashion. But importantly, he points out, which is germane to the analysis whether the learned judges were wrong in arriving at the conclusion they did, that the amendment power must be conceived as implicitly limited, even in the absence of any explicit limits. And he traces this back to the United States back at the dawn of the 19th century, refers to the works of John Calhoun in 1851, who wrote a book called Discourse on the Constitution and Government of the United States, and then also Thomas Cooley's Stories Commentaries in 1893. All these speak to the notion of intrinsic limitation to the amendment power, and it is not much different from the basic desire of Kenyans, I referred to earlier, that their constitution be altered only by the same means by which they made it. In Germany, the scholar Carl Schmitt was of the same view, that no revision of the constitution could provide for the destruction of its legitimacy. In short, the constitution does contain a core of implicitly unamendable principles which embody its identity. According to Rosenai, the argument in favor of implicit limitations on amendment powers did not remain in the realm of theory, but migrated from Germany to India in the 1960s, where, due to stormy political events, it was applied practically and most notably elaborated. I have indicated and traced the fact that that theory, doctrine, had an incremental fate in India. It was rejected in the case of Shankari Prasad versus India, and then it was again rejected in 1965 in the case of Singh versus Rajasthan. The first foothold of that doctrine was when a narrow majority of 6 versus 4 versus 5 of an expanded bench in Golaknath versus State of Punjab reversed those earlier holdings without invalidating the amendments in question. I need to mention here that that great break was contributed to by the writings of Dietrich Conrad, a German professor of Asian law, that had been placed before the court by one of the petitioner's lawyers, one M.K. Mambior, and I have indicated that this goes to show the value of research. When lawyers do good research, you get good results in the judgments. Now, the Golaknath decision, however, unleashed the wrath of our furious Prime Minister Indira Gandhi and signified the opening shot of the Great War over parliamentary versus judicial supremacy, and I've traced all that. When we came to Kesavananda, there was an extraordinary bench of 13 Supreme Court judges, and a narrow majority of 7 to 6 held that the amendment power does not include the power to alter the basic structure or framework of the Constitution so as to change its identity, and this is the kernel, the heart of the basic structure doctrine. Now, the majority faced reprisals from Gandhi, most notable being that her breaking with custom to appoint Justice Ray, the senior-most of the dissenting judges, as Chief Justice instead of the senior-most judge of the court, who happened to have been in the majority. Now, in Indira Nehru Gandhi versus Raj Naram, 5 judges unanimously confirmed the basic structure doctrine in 1975. Come down to Minerva Mills versus Union of India in 1980. Again, there was a unanimous holding that held that insofar as a certain section there removed all limitations on Parliament's amendment power, it conferred on it the power to destroy the Constitution's essential features or basic structure, and this was beyond the amendment power and thus void. Now, contrary to submissions that were made before us, the basic structure doctrine, from my reading of the cases subsequent to Kesavananda, demonstrates an ascendant trajectory to the point that it is firmly settled as a doctrine in India. The split majorities of its inception gave way to consistent unanimous decisions of the Supreme Court, so that the so-called compelling case by R. Dhawan, said to be a respected advocate and leading Indian scholar, that Kesavananda ought to be set aside would seem to have no solid foundation in my respectful view. It has stood for more than 50 years, or about almost 50 years now. When I turn to other cases, in Malaysia, for example, I have quoted 2 cases from Malaysia which seem to show that the doctrine was more accepted than repudiated. I have also taken time that taken note that other Asian countries such as Bangladesh and Pakistan have embraced and fully affirmed the basic structure doctrine. I've quoted some cases there. And citing various cases from faraway Central and South America, specifically Argentina, Belize, and Colombia and Peru, Rosenai comes to the conclusion that the basic structure doctrine has migrated far and wide across the globe. Some of the arguments that were made before us here were made in Belize, and the Supreme Court, in the case of British Caribbean, had this to say. They referred to the Indian basic structure and then said, though the Constitution of India is different in several respects from our Constitution, both constitutions have basic structures, features such as judiciary, rule of law, fundamental rights, and separation of powers. As I have stated before in this judgment, constitutional borrowing cross-pollination and interpenetration of notions is perfectly legitimate and is the proper way to develop the law while ensuring that whatever is borrowed is relevant, useful, and fitted to suit our particular circumstances. I need only add that the legal scholars have recognized and encouraged constitutional borrowing by courts for persuasive purposes, and there are all manner of articles. Can constitutional borrowing be justified? In the University of Pennsylvania Journal of Constitutional Law, and then constitutional borrowing in the Michigan Law Review. I note with a measure of bemusement that while castigating the learned judges for relying on foreign jurisprudence, the aggrieved appellants have laid before us numerous decisions of foreign courts. I was at first minded, I have mentioned some of the things that were quite off in the manner in which the submissions were made. We were told that cases said one thing when in actual fact they said something else. I'll give an example. In one of the submissions, it was said that in Uganda, the Supreme Court, in the case of Paul Semogerere and others, equally dismissed the Kesavananda doctrine. And then they quote a passage that I think was quoted by one of my colleagues this morning about those who make the Constitution know what's good for them, etc., etc. And then, but now, this is what I say. Now, after reading, from a reading of that passage quoted by counsel, the impression is that all those words were by Mr. Justice Tesekoko of Uganda. But in truth, only the last paragraph contains his words. Now, having read the Semogerere judgment myself, which was usefully, if ironically, supplied by counsel in volume 8, I cannot but respectfully conclude that the case does not at all advance the appellant's particular argument or case. First of all, it turns out that the bulk of the excerpt attributed to Judge Tesekoko are not his words. They are actually words apparently found in a Kesavananda dissent, which the judge quotes not directly from the judgment, but as said to be quoted in a Singaporean case. The judge himself puts it thus at page 8 of his judgment. He said, no copy of the judgment of Kesavananda case was availed to us. I have not been able to lay my hands on the full judgment, but passages of it are quoted in the Singaporean case of Sesolung. Now, with great respect, I cannot see how it is possible for Semogerere to have dismissed Kesavananda, as we are urged, when the judges deciding it had not even engaged with the doctrine and had not even read the judgment. In fact, nowhere in Semogerere is there a whiff of rejection of the basic structure doctrine, which is the heart and essence of Kesavananda. To the contrary, Tesekoko J. indicated that in his considered opinion, Kesavananda case was misunderstood and therefore misapplied to the petition that was before the Constitutional Court. And then he talks about what he thinks Kesavananda, which he didn't read, was about. Now, I need not say anything on the judge's understanding of the issue in Kesavananda, which I, unlike he, have read in full. But it should be obvious that given the infirmities I have pointed out, Semogerere, as presented before us, cannot be a basis for the contention that the basic structure doctrine was rejected in Uganda on that occasion. The same also goes for the case of Male Mabirizi and others versus the Attorney General of Uganda, where it seems to say, the judge said that the basic structure doctrine is still at a nascent stage of development. This is a 2018 decision, but from what I've said, the basic structure is not nascent, it's not new, it has actually grown quite old. Now, having undertaken so detailed an account and analysis of the Indian experience with the basic structure doctrine and its migration across the globe, I have no difficulty discounting those conclusions as untenable. I would also reject the decision cited to us of the Honorable Attorney General of Tanzania versus Christopher Mtilika, because there the court said, the Court of Appeal of Tanzania, it said that the courts must eschew a loosening of judicial discipline in interpreting the explicit provisions of the Constitution. And they went on to say that a tightening of judicial scrutiny would be necessary. Now, I think that is the very antithesis of what our Constitution requires of our courts. I cannot accept as a correct reading of the Constitution, less still a persuasive one for me to follow, the conclusion reached there that everything is amendable once the procedure for amendment is followed and that the basic structure doctrine does not apply. The conclusion I have arrived at, out of my forays into the jurisprudence and learning I have referred to, and much more besides, is that the basic structure doctrine is legitimate and sound. I would think it's strange that anyone would doubt the existence of a basic, fundamental, essential core, being the pillar upon which the Constitution stands, and from which its character, ethos, and identity flows. There is a certain undeniable simplicity to the notion. I thought of it as a house. Any and every house, be it simple, complex, and elaborate, must have some structure with its bare essentials. Even as some houses have fewer items than others, going into their basic structure than others, so would different constitutions differ in complexity. I was pleasantly surprised to see that Joseph Raz, in a book called Between Authority and Interpretation, uses the analogy of a house to differentiate between minor changes to the Constitution, like redecorating a house, and major ones that alter its character. Rosner refers to that very analogy of a house. I will not say much more on what he says. I've cited a passage at length to signify my full agreement with the learned judges that the amendments proposed by the BBI initiative and bill were so far-reaching in character, scope, and content as to shake the foundation and alter the identity and character of the Constitution. They were effectively dismembering the Constitution, blasting so huge a hole in it as to pulverize its foundations and essentially create a new constitutional order. To do so would not be to amend the existing Constitution, and therefore there was need to resort to and summon the primary constituent power. The mere invitation of the people to vote on the radical transformative proposals at a referendum was not an effective summons of the correct authority, because the people acting on the amendment plane constitute the secondary constituent power only and are limited to amendment. They are in no position, while acting in that capacity and space, to endorse and effect a constitutional replacement. This latter they can only do in primary constituent mode. Now, Rosnai, I believe, asserts crucially that the amendment power is a constituted power even if exercised by the people. Moreover, no constituted power should be entitled to abolish the democratic system. To my mind, that is the cognitive posture that we should adopt in answering the question whether the notion of limitations to the amendment power discussed by so many courts loses any of its logical force by the fact that the amendments proposed in the case at bar and contemplated by Article 255 and 57 of the Constitution require approval by the people in a referendum. The conclusion appears to me inescapable that as long as what is contemplated is an amendment, it will ipso facto be limited. The limitation in this case stems from the fact that certain aspects of the proposed amendments unquestionably go to the essential core and fundamental fabric of the Constitution, thereby purporting to alter irredeemably its character and identity. Such radical alterations are not amendments in the real sense of the word, for there has to be a limitation to what amendments can achieve. And I would think that dismemberment is dismemberment, whether effected through surgical amputation or through rough mutilation. It matters not whether you carve Caesar as a dish fit for the gods or hew him as a carcass fit for hounds. The cats are mortal either way. I have said enough, perhaps more than enough, to show that I do not think a sufficiently compelling case has been made to warrant our interference with the conclusion that the learned judges reached with regard to the basic structure doctrine and its applicability in Kenya. I have gone back to what Lenaola J had to say in the Commission for Implementation of the Constitution, was National Assembly. I am fully in concord with the reasoning. I'm so fully in concord with the reasoning of Lenaola J that I will not add a single jot or tittle to his reasoning. Having come to the conclusion that the basic structure doctrine is applicable, The conclusion is also inescapable that the amendment power set out in Article 255 to 257 of the Constitution is limited, and that the basic structure can only be amended through the constituent power. That constituent power can only be properly summoned and exercised in accordance with the four-sequence process of civic education, public participation and collection of views, constituent assembly debate, preceding a referendum. And this accords with the holding in Joya. I would hold without hesitation that a referendum cannot be effective as contemplated by the constituent power unless the initial three steps have been involved and engaged in real and substantive, as opposed to a ritualist and minimalist manner akin to a mere token ticking of boxes. Ringera J said, all in all, the limitation of Parliament's power was a very wise ordination by the framers of the Constitution, which is worthy of eternal preservation. I think, with respect, that the amendments to the Constitution contemplated and proposed by the BBI Amendment Bill have the potential to alter by one fell swoop the fundamental pillars that define and undergird our Constitution. They are truly no less than a ballistic attack on our Constitution's foundations, including separation of powers, independence of the judiciary, and Chapter 15 commissions and independent offices, not to mention supremacy of the Constitution, sovereignty of the people, and the national values and principles of governance. I accept that this is not exhaustive and should be dealt with on a case-by-case basis. Ringera J indicated that we have been down this road before, but without judicial challenge. I surmise that a cowed populace probably did not have the courage to seek redress, nor was the judiciary back then particularly famous for the defense of the Constitution. For the superior courts of this country at this time, there is no luxury of indifference or neutrality. Where in former times no challenge to the manifest alteration of the Constitution's basic structure was made, thus sparing the court the burden of decision, we are today summoned to the valley of decision. Civic-minded Constitution-defending citizens have raised alarm at the threatened dismemberment of the 2010 Constitution. The High Court has, with crystal clarity of reasoning and felicity of dictum, raised a barricade against such a scheme, and it is upon these courts to either raise the bulwarks of defense even higher and place around the Constitution a wall high and impregnable against such machinations, or, as we are urged by the appellants, we disable the brakes, uproot the ramparts, and usher in an open season for the systematic and unbridled dismemberment of the Constitution. To me, there is only one path that commends itself consistently with conscience and fealty to the constitutional command. I must defend it and keep its fortifications firm and effective. I must stand up for the Constitution, heeding the words of the hymn, where duty calls or danger, be never wanting there. I have referred to the aspect of illiberal democracy and its growth, and I've talked about Professor Rosalind Dixon and David Landard. The point they point out that the constitutional amendments or basic structure doctrine, though at times attacked as being anti-majoritarian and making courts too powerful, is in fact a useful tool to help preserve so-called fragile democracies against the democratic erosion that is inherent in abusive constitutionalism. Beyond textually stated eternity clauses, they point out that many scholars and courts have argued that the doctrine can be defended. Now, however, given I am persuaded that the referendum requirement is at best an exercise of the people's secondary constituted power, or, as argued by some, an aspect of the constitutive power contemplated by the Constitution itself as part of its amendment procedure, I am better persuaded by the constitutional amendment / basic structure doctrine. I am justified by this view, by my appreciation that even referendum procedure can be made of no effect by a deficit of prior civic education and public participation. Indeed, someone has said that For populists, a referendum isn't meant to start an open-ended process of deliberation among actual citizens to generate a range of well-considered popular judgment. Rather, the referendum serves to verify what the populist leader has already discerned to be the genuine popular interest as a matter of identity. An effective bulwark against abusive constitutionalism, therefore, seems to me to be on the authorities, one that entails more as opposed to less people involvement. I think, therefore, that there is nothing anti-majoritarian or doctrinally abhorrent about the four-step process the learned judges held to be indispensable for effectuation of amendments of the kind proposed by BBI. It has to be recalled that the restriction to amendment need not be in express text. It is generally accepted that in keeping with the interpretive posture addressed earlier in this judgment and on a proper understanding of the basic structure doctrine, the limitation can be implicit. Therefore, it is the people themselves who preferred rigidity over flexibility. They were bothered by hyper-amendability, and for me, the numerous amendments proposed are no less offensive because they are presented in one bill at once and not through staggered installments over time. Justice Chandrachund in Casavananda stated that the basic structure's theme song is "Amend as you may, even the solemn document which the founding fathers have committed to your care. For you know best the needs of your generation. But the Constitution is a precious heritage. Therefore, you cannot destroy its identity." In short, it is undeniable that by using the basic structure doctrine, the judiciary does play an important role against democratic erosion, and I would, without hesitation, affirm the learned judges on the basic structure. My voice is running out, so I will just make a few comments on the other issues. Popular initiative. I have held that in the amendment scheme of the Constitution, it is clear beyond peradventure that as far as the characterization of the amendments to the Constitution go, there is a binary reality with two distinct, dichotomous, and disjunctive initiatives, the parliamentary one or the popular one, each providing a distinctive methodology or procedure. And what appears clear from the Kenyan experience is that the popular initiative was introduced as a response to citizens' frustrations with Parliament, to whom the law-making power is delegated. It was not always acting in a citizen-centric manner and often acted in a manner quite inimical to the interests of the public. The popular initiative is therefore a mechanism for the people to exercise direct authority in the amendment of the Constitution. It is a power reserved to them as the sovereign to do that which Parliament may have defaulted in doing. This is consistent with Article 1, Sub-Article 2, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Admittedly, this form of active, direct, and deliberate democracy is quite new in the African experience, but has been around for quite a while in other parts of the world. Referred to variously as the constitutional initiative, mainly in America, or citizens' initiative in Europe, it has certain discernible characteristics which are pointed out. Now, one of the things to note is that in an article by Maya Setale and Theo Schiller, editors, Citizens' Initiatives in Europe, Procedures and Consequences of Agenda Setting, the author draws a valid and useful distinction between compulsory referendums, which are for constitutional changes proposed by the government or the parliament, and the popular initiative, which allows for any other group outside of the parliament to put a proposal on the table. By the term popular or citizens' initiative, we refer to procedures that allow citizens to bring new issues to the political agenda through collective action, that is, through collecting a certain number of signatures in support of a policy proposal. The role of these citizens' organizations, social movements, civil society organizations, etc., they are the ones who lead the citizens. The role of these organizations outside of formal representation through parliament is the answer to the political marginalization of the citizens, famously expressed by Jean-Jacques Rousseau in the social contract this way, and which might have universal application. He said, the English people, and you could put any other people there, the English people think that they are free, but in this belief they are profoundly wrong. They are free only when electing members of parliament. Once the election has been completed, they revert to a condition of slavery. They are nothing. End of quote. It includes, in the perspective, other optional plebiscites which are identified as presidential, governmental, or parliamentary initiatives. And these are contradistinguished from the direct democratic perspective that trusts in the people to initiate the direct decision-making process. In this range, we have the popular initiative, the popular referendum initiative. From my reading of the literature on these subjects, I am fully fortified in my view, which coincides with that of the learned judges, that a popular initiative is a citizen-conceived, citizen-initiated, and citizen-driven process. And these are the ordinary mwananchi. If the initiative is born of presidential fiat, no matter how well-intentioned, it ceases to be a popular initiative and must be recognized and named a state or presidential initiative. Now, in answer to the question whether what happens when the president has a parliament that doesn't listen to him, I do not doubt that the president, with his wide array of powers and influence, could have used the parliamentary initiative through his party and others with which he works, or could work in a coalition of the willing to bring about the changes to the constitution that he seeks. The president's role in the conception and initiation of the Building Bridges initiative is writ large, and with it the panoply of power and prestige of his office. First was the handshake, then the BBI Gazette, which was appointed by task force was appointed by Gazette, which is an official government publication. The task force prepared a report which it presented to the president as president and commander-in-chief. Moreover, the president again appointed the steering committee on the implementation of the BBI report by way of a special issue of the Kenya Gazette. Their report was presented to the president at a state lodge. That everything about the process bore the imprimatur of state involvement. It was a presidential government project, and this was wholly antithetical to the popular initiative. Like Machiavelli's prince, the president's conduct is different from that of ordinary citizens. In acknowledging this plain and in spirit of fact, one does not thereby curtail the president's enjoyment. One might even say deployment of his personal or political rights. All it means is that the space upon which he elected to exercise his rights is reserved for ordinary citizens, the common populace of the Republic of Kenya, and it is not open to the president. It is out of bounds to him. The question is, first of all, hypothetical, but to my mind, the president does not shoulder any obligation to initiate constitutional changes. He takes office under and in accordance with the Constitution, and his duty is to obey and defend it in keeping with the oath of allegiance, not to change it. It follows from my reasoning that I agree with the learned judges that insofar as the president took certain actions at the inception of the BBI process, including appointing the task force and later the steering committee by Gazette notices in his capacity as President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the popular initiative path, a preserve of the ordinary citizen, was not available to him for initiating any amendments to the Constitution. I would dismiss the grounds of appeal challenging that finding. Next, jurisdictional objections. I do not think there was any merit in the claim that the matters were either sub judice or were res judicata, and I've dealt with that wholly. I agree with the judges on that point. Let me rush quickly to the legality of the BBI process. I've said things there that initially that already give an answer to this. But given there was never indication, I should start here. A number of critical facts stand out in crystal clarity from that Gazette notice which appointed the steering committee. Regarding the steering committee, which taken singly, together, or wholly, go to declare that it was a presidential creation and a government project tasked with inter alia proposing constitutional changes for the implementation of the report of that very team in its previous emanation as the BBI Advisory Committee, and the facts are there, I've stated them. Given there was never any indication that citizens of this country had, in and by themselves, conceived of the idea to change the Constitution in a particular manner as the genesis of this process, but appear only to have been roped in to respond to what had already been given life and motion by the president when he appointed the task force, the process that was being undertaken was not a popular initiative. And it matters not that it may eventually have gained the liking or admiration of many people. That sense of popular is not what is meant by the Constitution, which uses popular in the sense of pertaining to the general public or ordinary citizens. The BBI Steering Committee, by inception, composition, and operationalization, was a government presidential project. The members were not ordinary citizens who came together, coalescing around an idea that the Constitution needed to be changed in particular respects. Instead, these were prominent personalities joined together by presidential fiat. They had no mind or idea of their own to initiate, but were instead tasked to identify constitutional, among other changes. It was not open to them to purport to craft constitutional changes and even come up with the BBI Constitutional Amendment Bill purportedly as a people's initiative. They were, without a doubt, a government project, and it was impermissible and untenable for them to seek to camouflage their process as a popular initiative, which it was not. They were essentially seeking to hijack the People's Initiative route under Article 257 of the Constitution, and this was clearly intolerable and indefensible. It was also contrary to the letter and intent of the Constitution. That, I think, provides the answer to what I had to say about that aspect. Yes. I think I am dealing with... yes, public participation is the next point. And under public participation, I have indicated the Constitution itself, a product of super participation on the part of the people of Kenya, recognizes participation of the people as one of the national values and principles of governance. It is listed in Article 2A alongside patriotism, national unity, sharing and devolution of power, the rule of law and democracy. I have no hesitation holding that participation of the people is what gives meaning to and serves as the guarantor to the tangible realization of the other values and principles of governance. It is what gives substance and brings to life as a present reality the idea that democracy is a system of government of the people, by the people, for the people, as famously put by U.S. President Abraham Lincoln in his Gettysburg Address on November 19, 1863, which he hoped shall not perish from the earth. Participation by the people is in the matters that concern them, when done in a deliberate, substantive manner, acknowledges the sovereignty of the people and treats them as master of their own destiny. Their autonomy, individually and as a collective, is mainstreamed, even as the paternalistic state and its officers that so easily assume the position of ex cathedra directives recede to a facilitative as opposed to a command position. Once the people are involved in policy formulation, legislation, and in the greatest, most solemn role of constitutional amendment, they get to own both the process and the product. They are no longer pawns on a political chessboard. They are not mere voting machines at the beck and call of political operatives. They are not commodities for sale to the highest bidder. They retain ultimate control over government and are not at the control of government. The Constitution says so, and it is the duty of those who enforce or interpret the Constitution to give real meaning to the principle in its widest and fullest manifestation. Now, I have said many more things about public participation, but long and short, yes, there's an aspect. I agree with the judges generally when they talk about public participation, but whereas the above reasoning is perfectly in line with the public participation, with what it would require in a matter of such moment as constitutional amendment, I must express my unease, brought out quite poignantly by Mr. Karori in his address to us, that it would be to place an onerous and well-nigh impossible burden on promoters of a constitutional amendment by popular initiative to expect them to go the whole hog, captured in the above excerpt, including translating it into all the languages, having it in Braille, etc., and sending it all over the country. That to ask them to do that before they collect the signatures might be a bit too onerous. It seems to me, with respect, that the requirement stated by the judges must be present before or at the time of the voters finally make their decision on the proposed amendment of the referendum, failing which the mandatory requirements for public participation will not have been met, with fatal consequences to the proposed amendment. I am of the view, however, that the elements of public participation stated must perforce be understood to form a spectrum or a continuum which is incremental in character. It would be way too expensive and onerous to expect that citizens seeking to introduce amendments, be it by way of a general suggestion or a formulated bill, must engage and involve the voters generally, by which the learned judges must be understood to mean the national vote pool, from whom the promoters would be seeking the 1 million supporters, to the broad and extensive elements of public participation enumerated by the learned judges. I think that the duty they bear at that point of signature collection is one of sensitization with candor and disclosure, as opposed to one of full broadcast by all means, in all languages, to all voters of the full particulars of the exact amendments by way of the amendment. It is enough that a voter should know what is sought to be introduced by amendment in sufficient detail to be able to make a decision whether it is an initiative he would support by appending his signature at that stage or not. To that extent only, would I respectfully fault and reverse the learned judges while leaving intact their reasoning and holding on public participation with regard to the totality of the process up to the referendum. Of course, it has been argued that why worry about public participation? The way you look at everything else, the way it is set out, there will be enough moments for public participation, and perhaps the judges acted too fast and too soon. And I think, with respect, that whereas on paper the argument does sound attractive, the reality on the ground, as became apparent during the hearing of the appeal, is that there was a measure of cynical disregard for the very opportunities and timelines intended to facilitate public participation. Even for the signature collection, for instance, it turns out that the IBC apparently published the list of the persons listed as supporters of the initiative to facilitate confirmation by the people that the list was accurate, thereby seeming to involve them. This was in reality a mere show, devoid of substance, however, for the reason that the list was published by the IBC on the IBC website only, and then the public were informed of the fact on Thursday, 21st January, and were required to have notified IBC of any complaint by the following Monday, with a weekend in between. It means that the people of Kenya were given but 2 days to access information available only on a single platform. Under those circumstances, it sounds rather strange for IBC to point at the apparent absence of complaint as demonstrative of accuracy or satisfaction. It could well have been due to absence or, at the very least, insufficiency of access. Another glaring and troubling example that was cited in argument before us was the lightning speed at which the amendment bill was rushed and passed through county assemblies. The Constitution deliberately indicates that they are to consider the bill within 90 days. And it is argued that properly so, that the period is intended to facilitate public participation, which I take to take the form, at the minimum, of publication of the bill within the county, followed by consultation, receipt of memoranda, debate in public forums organized for the purpose, and on other platforms so as to involve the people and obtain their instructions, thereby establishing whether or not to support or approve the bill. What was witnessed in most counties, however, was a farcical disregard for the people and the Constitution. Many county assemblies made absolutely no pretense to involve the citizens resident in their counties, spurred on no doubt by certain incentives beneficial to themselves, the most notorious of which was their demand for some 2 million shillings car grant, which was quickly granted by government. The usually slow and tight-fisted Salaries and Remuneration Commission, despite well-known fiscal challenges and a raging global pandemic, somehow managed to prioritize, approve, and find funding for that particular incentive for MCAs, which seems to have attained the status of a national emergency. What in the end seems to have happened in county assemblies was a mad rush to demonstrate personal gratitude and party loyalty, with some passing the bill in but a couple of days. The people did not matter. They might as well not have existed. And no superior court in this country, properly directing itself on public participation, would in conscience accept as permissible such violation and negation of the constitutional scheme and command to put the people first and center in public affairs, of which amendments to the Constitution is definitely the most solemn. I would affirm as correct the holding of the learned judges that county assemblies are under duty to approve or reject a constitutional amendment bill in a popular initiative whole without amendment, so as to maintain and preserve its content and character inviolate as a popular initiative. It is also the more reason why they are under a clear duty to be scrupulously and faithfully discharged, to involve the people so as to discern which way they should vote on the amendment bill. On presidential immunity, all I will say, first of all, is that there was an issue that the His Excellency the President, Uhuru Muhammad Kenyatta himself, it would have been neater. It would have been neater if the President himself joined the proceedings and raised objection to his having been sued in his personal capacity. But he was not. Now, the issue that arises is that he appears not to have been served. And I might as well state at this point that the learned judges ought, at the very minimum, to have first satisfied themselves that service had been effected on him by the petitioner before proceeding to hear and determine the matter, and to even make pronouncements against him. This is a fundamental and basic tenet of natural justice, and the rules as to service or process are quite explicit as to what is required to have been done. I therefore agree with Mr. Gatonyel, Senior Counsel, that any adverse orders made against the President in his personal capacity would be open to setting aside ex debito justitiae. That does not mean, however, that the learned judge's finding on the extent of the President's immunity from civil suit is also affected, because this is a matter of constitutional law, not personal to the sitting President. And I have quoted Article 143(2), and the argument was that the President should be impeached in case of things that happen outside of his. In fact, the argument was that he enjoys absolute immunity. Now, as an impeachment can be challenged in courts, it was counsel's view that it was putting the cart before the horse for the courts to entertain suits against the President in his personal capacity before he gets impeached. When seeking clarity, I asked counsel the hypothetical question of what my neighbor out in the village of Karaos, Kesogon, Trans Nzoia County would do were I the President and my dog bit his child. It was counsel's confounding answer that the only recourse open to my neighbor was to seek my impeachment. He cannot be right, not least because there is nothing presidential about such a canine indiscretion that would only invite tortious liability. Counsel drew the attention of the court to Article 165 of the Constitution that gives judges immunity, and in particular the case of Bellevue Development Company and Francis Gikonya and 7 others. I am familiar with it. I wrote a judgment in it. But the position I take, is that the protection that is given to the President has to be purely functional, related to his office, and does not extend to any matters that are done outside or in violation of the Constitution. In fact, from my analysis, it is possible to state the law on presidential immunity to be this: the President is immune from criminal prosecution and from civil suit for any act or omission in exercise of his powers under the Constitution in Kenyan courts during his tenure of office. But he may be sued for acts or omissions outside his constitutional duties and prosecuted for international crimes where the treaty establishing them does not recognize the defense of immunity. The statutory limitation period shall be extended to take account of any action or suit that could not be brought on account of the defendant's presidential tenure. I make a distinction between this and the immunity that the President had under the old Constitution, where it was absolute. And I would say that absolute immunity, which existed under Section 14 of the retired Constitution, appears to me to be an anachronism and an oxymoron in the context of a constitutional democracy such as we are, that upholds as part of its national values and principles of governance the rule of law, good governance, integrity, and accountability. Those values and principles, alongside constitutionalism, which denotes limited government, denotes limited government, must mean that the office of President, being a creature of the Constitution, is and must be subordinate to the Constitution, and its holder must be held to account for his acts and omissions. The President is not above the Constitution or the law, and is not a law unto himself or herself. In recognition of that preeminence and importance of the office of the President, the Constitution grants protection to the holder thereof, to the end that he should not be unduly impaired in the performance of his unique duties. That protection cannot, by any stretch of imagination, be extended to cover any and every act or omission, including those outside of or in violation of the Constitution. That seems to me to be the clear meaning discerned from Article 143(2), and the fact that Article 143(4) expressly excludes international crimes from the purview of presidential immunity provides ample proof that its limited conception, character, and extent. Now, the president does not possess powers outside or beyond those donated to him by the Constitution and the law. He, as well as all holders of state and public office, must point to the Constitution or to a law to provide a basis or justification for the powers they wield and exercise. The rule of law demands, as Professor Wade put it, that each act must be shown strictly to have legal pedigree. Indeed, if you look at the case of Nixon versus Fitzgerald that was cited, you will discover that the absolute immunity that the former president, Richard Nixon, was held to have was from damages liability predicated on his official duties, official acts. The immunity was held to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by the U.S. history. Now, what we have in issue here, coming out of petition number 426 of 2020, are those acts which are said to have been committed by the president outside his constitutional powers and in fact in contravention of the Constitution, and the learned judges held, and I would respectfully affirm, that the president is not immune from suit for that. I only need to add that the days of an accountable presidency are long gone and are of only historical significance as a lesson and a warning to the citizens of the country to be vigilant and to demand accountability from the person to whom they entrust the responsibility of leadership. Experience, as recorded in many cases, both local and comparative, shows that in a democracy, no office is immune from accountability to the law as administered by the courts. I hold that the appeal challenging the learned judges holding on presidential immunity from suit in personal capacity should fail. Regarding the legal regulatory framework for constitutional amendments by popular initiative, I have mentioned some of the arguments that were made, and I would say that I think it's a matter too plain for argument that the country does need a referendum act, and there is none at present. The learned judges were informed that there was a proposed referendum bill somewhere in the legislative pipeline, but there seems to be uncertainty as to its eventual fate. So, it's interesting that, and odd that the Attorney General, who should have been at the forefront in seeing the legislation is in place, the IBC, which needs it for proper conduct of referenda, and the BBI Secretariat, which needs it to be guided by it if it were to pull through the proposed amendments, all seem to speak the same strange language, that the gaping lacuna is of no significance or moment. With great respect, I do not find such a stance by critical players in a national exercise to be of great importance to be particularly helpful. And I do hold the view that candor in public affairs, including in litigation, is a virtue to be embraced. It cannot be right for parties to propound in court positions they know to be so plainly untenable, and to do so without batting an eyelid. That this country needs a referendum act is an urgent matter and should have been addressed years ago. Now, the Attorney General went on to assert that all motions involving the furtherance of popular initiative are an exercise of citizens' political rights as enshrined in Article 38, but they should not be limited by flimsy excuse of lack of regulations, administrative procedures, or statutory prescriptions not expressly provided for under the Constitution or legislation. That's what the argument was. Whereas the Attorney General is quite right that the enjoyment of fundamental rights cannot be conditioned upon the enactment and promulgation of any statutory rules or regulations, with the absurd result adverted to where rights are held at ransom by official neglect, I do not think that the learned judge's decision was to that effect. I fear the Honorable Attorney General appears to have misapprehended the reasoning of the learned judges, which was quite the opposite of the meaning he ascribes to them. In fact, judges at paragraph 6 or 3 of their judgment say that even if there is no referendum act, it is still possible to under proper with proper adherence to the Constitution, to go right ahead and hold a referendum. I think, with respect, that given the uncertainties, ambiguities, and penumbras that are apparent in the manner in which one is to go about initiating, collecting signatures, forwarding, debating, involving the public, campaigning, and voting on a popular initiative for the amendment of the Constitution together with the necessary timelines, this area is in a wholly unsatisfactory state and needs clarity by way of both national referendum law and probably rules and regulations specific to the popular initiative. It is disingenuous for it to be argued otherwise unless uncertainty in law should somehow have attained a utility I myself cannot discern and state as of a virtue. I am firmly persuaded that a referendum in the context of proposed constitutional amendments by popular initiative must be governed by a specific, properly thought out legislation. It cannot be left to the Elections Act, which seems to contain a part of the referendum in some kind of by the way or afterthought, regard having heard to the fact that referendums are not elections and they are no less important than elections. I would go as far as to state that whereas the provisions on the referendum in the Elections Act may suffice to settle questions of various types and descriptions in an ordinary referendum, they are not sufficient in detail and clarity and were not formulated to meet the full requirements of Article 257. I should think with respect that it speaks to a national malaise of inattention to duty, a satisfaction with dilatoriness, and being reactive instead of proactive on the part of officialdom, that the referendum law has never been passed, notwithstanding that some 2 years ago, Justice Nyamweya had spoken, Nyamweya J, as she then was, had spoken of its glaring need in the case of Republic versus County Assembly of Kirinyaga, ex parte Kenda Muriuki, and another. Now, in resolving this issue, the issue of verification, I've gone into some depth about it. All I can say that the report was even more emphatic. This is a report that was done by IBC itself in the Okoa Kenya initiative, was even more emphatic on the process of verification, which must entail ascertainment that the status of the supporters of the status of the supporters as voters and of the authenticity of the signatures as theirs. I agree entirely with the sentiments of the judges, safe to say that the landed judges were perhaps too magnanimous in having been merely startled by IBC's flip-flopping on this rather straightforward matter of what it means to verify. I should think that such shifting of goalposts probably smacked of Kanda economy, calling for stern rebuke. It is a matter of utmost importance that all persons and institutions that appear before court be careful to be entirely forthright. Any other contrary stance brings the administration of justice to disrepute and must not be condoned or normalized. And therefore it boggles the mind that with regard to the BBI proposed amendments, IBC sees its role as different from what it stated with regard to the Okoa Kenya initiative. In sum, there does exist with regard to the counterpart electoral processes full-fledged legal and regulatory framework, and it cannot fall from the mouth of IBC that a like framework for signature verification for a popular initiative is a superfluity, because I think it is not. Given that state of things, I am convinced that the conclusions reached that IBC lacked the requisite legal and regulatory framework in the specific issues of signature verification and that the stopgap administrative procedures were invalid, were unassailable, and I would not interfere with them. On IBC quorum, I think a lot has been said. I am in total agreement with my brother, Justice Gatembu, when he came to the conclusion that the quorum of IBC cannot be 3. The quorum of IBC must be 5. And to my mind, such a vital role done by IBC requires the full complement of IBC with all hands on deck. It is to me another instance of officials' failure on the IBC, which, while fully aware of its current limping status, its commissioners having dropped to below half of what the Act prescribes, for it to wear a brave face and state in legal proceedings no less that it's doing just fine. A more honorable stance would have been for the IBC and the Attorney General to make a clean breast of it and consider the former needed urgent help and send an SOS to the appointing authority to bring that intolerable state of affairs to an end by making the necessary appointments to empower IBC for the performance of its key mandates, including the conduct of referenda as stated in Article 884 of the Constitution and required in Article 257. Its relevant statute demands immediate filling of the positions of commissioner that fall vacant. It is fortuitous that interviews have since been conducted and IBC should shortly be fully constituted and not a day too soon. I think I can leave that particular one and move on to, I would therefore agree with and affirm the landed judges holding that all the decisions made by IBC in relation to the proposed constitutional amendments via the BBI Amendment Bill were invalid, null and void for lack of quorum. On voter registration, again, I've said quite a bit, and the evidence seems to be that IBC had managed to register some 108,000 more voters after the time of the Kibra election of 2018. During argument of the appeal, it came out quite clearly that there really has not been any serious and sustained continuous voter registration. It is also clear that the numbers indicated are measly, to say the least, when thousands of young people are daily attaining the age of majority. And I would say, and not accept the argument made before us that it was upon the petitioner to prove the contrary. He bore no burden, because it is the IBC that keeps the records, and it is it that had the duty to show that there was continuous voter registration. It would have been an unacceptable dereliction of duty and violation of rights were the referendum to be held with hundreds of thousands or millions even of young people sitting it out on account of not being registered. Where the referendum in question involves proposed changes to the Constitution, it is this very segment of the citizenry, the very youngest of adults, who have the greatest stake in the matter, and everything should be done to aid in having their voice heard, their vote taken, and their decision made known. Indeed, it's further testimony of the nonchalance that attends the question that the registration of young people as voters is a matter that has to be pursued as a chore, when attainment of majority ought to lead to an automatic registration as a voter. I know that the report by the Curricular Commission dated 17th September 2008 on this very aspect has never been actioned more than a decade later. They had indicated that it should be very easy. The moment someone gets an ID, they should also be registered as a voter, but that seems not to have been done until now. The format of the referendum question, I would say with respect, again, I agree that lumping all those questions together brings a problem. But first of all, the argument was made that we judges, the judges should not have told the IBC how to go about it, because that is trying to control them. But I suggest that I do not understand independence of commissions to mean that they are anyway beyond being told by the courts what the law is. Now, if I may pause here for a moment, it becomes clear that some amendments to the Constitution do not require the involvement of the people generally at a referendum. And one of the problems of the IBC bill is that it contains both matters that require a referendum and others that do not. It contains multiple and altogether way too many proposed amendments, some of which would require a referendum while others do not. The confusion becomes intolerable in that a bill is prepared containing provisions that from their different proposed impacts requires two different tracks for enactment. Indeed, because of the numerosity of the questions, I think I have said that I do not for a moment think that it was ever the intention of the people that amendments to the Constitution should be the normal done thing whenever we feel the urge. It should come rarely, and even then when compelled by the greatest necessity. And for that reason, an amendment should come singly, once, rarely. If for any reason, and I cannot readily conceive of any, amendments must be brought other than singly, the original intent must be maintained by having each amendment presented separately and distinctly to be voted upon independently. That way, the choice presented to the people is not a binary one, and the people do not have to feel ramroded into choosing what they do not like alongside what they like, or vice versa. That Hobson's choice may perhaps be avoided by way of a multi-option referendum, but I will refrain from making any conclusive findings on it in the absence of a referendum act, the desirability of which I have already addressed under the rubric of legal and regulatory framework. I have taken the view that whereas Section 49 of the Elections Act does envision multi-question referendum, I would think, however, that whereas the section applies to referendums generally, the specific proposed constitutional amendment under People's Initiative in Article 257 must be presented as a single amendment at a referendum for the people to either approve or reject. On the whole, therefore, I do find and hold that the learned judges were right in holding that specific proposed amendments must be submitted as separate and distinct referendum questions. I would only preface the relevant part of the declaration by the words must be presented singly, or I would in any event reject the grounds of appeal preferred against the holdings on the structure or format of the referendum question. I've taken the view that having too many of them in one question amounts to an interrogatory overload. On the question of constituency, apportionment, and delimitation, I note that IBC, which to its credit has not appealed against the findings of the learned judges on the aspect of the case, is required under the BBI bill to determine the boundaries of the 70 extra constituencies within 6 months of the commencement of the Act in the counties among which the new constituencies are spread in the manner specified. The learned judges undertook a detailed historical account of constituency delimitations, which goes to show how the matter is a delicate, emotive, and often highly contentious exercise undergirded by what Kriegler report termed the gross disparities in the voting populations and gross disparity in the size of Kenya's constituencies. In a report by the IIBRC, it identified historical injustices and past gerrymandering as having highly contributed to the 2007 post-election debacle. Now, I have generally agreed with the learned judges, and I hold without hesitation in rejecting the complaint that the learned judges erred in not exercising judicial restraint or constitutional avoidance, that I am in full agreement with this court reasoning and holding aforesaid, and that is in the case of Coalition for Democracy, CORD versus Republic. It resonates with what I stated earlier when treating of the basic structure doctrine, that the Constitution places on judges an unmistakable obligation to defend the Constitution where there is real, clear, and present danger of violation or contravention of rights or an unlawful tinkering with or alteration of the Constitution's basic structure, such as portended by some of the provisions of the BBI Amendment Bill. The courts, when moved, must take defensive action in aid of the Constitution, even by making a preemptive strike that ensures the threatened unconstitutional constitutional amendments do not see the light of day. I have again seen refer to Mr. Karori's arguments in which he talks about the difference between the power of IBC over wards and over constituencies, which I agree with, but a careful reading of the judgment does not suggest to me that the learned judges held that the number of constituencies cannot be altered. I think they stated the opposite, and quite emphatically and unambiguously so, which again I have quoted them. What the learned judges did hold was that it was impermissible for the BBI Amendment Bill to directly allocate and apportion the 70 extra constituencies it created without the delimitation exercise that is commanded and provided for in detail by to be undertaken by IBC in Article 89, which lists and Article 88.4, which lists the delimitation of constituencies and wards as one of the particular, and I dare say, exclusive responsibilities of IBC. To my mind, the protective role of independence commissions over the sovereignty of the people is of critical, over the delegation of the sovereignty of the people is critical and vital importance, and can only be attained by a jealous and uncompromising assertion, exercise, and defense of their independence. Independent commissions are charged with the duty of vigilantly and keenly ensuring that the state organs to which sovereign power is delegated maintain the stance of delegates accountable to their principles and remain always the servants of the people. And therein lies the absolute necessity of the independence of those commissions being kept firm and inviolate. I would thus hold that seeing how critical the independence of independence commissions is to the sovereignty of the people, it has to be part of the basic structure of the Constitution, which is given express amplitude by entrenchment. Having taken this view, it should be obvious that I find the provisions of the BBI Amendment Bill to be an unconstitutional attack on the independence of the IBC, and materially seek to alter by the operation of various of its provisions the limitation scheme set out in Article 89.1 of the Constitution. It effectively attempts to repeal that provision without saying so by stealth and subterfuge. Now, it is a statement to the thoroughness of forensic analysis and intellectual engagement the learned judges brought into this aspect of the case, as indeed the entire case, that they proceeded to expound on in some detail on each of the 6 reasons or markers of unconstitutionality that they identified in the BBI bill. I'm not to go into them. As I am myself fully satisfied with the accuracy and logical legal foundations of those reasons, I do not consider necessary to rehash them. The conclusion is inescapable that being so violative of the Constitution, the provisions of the BBI Amendment Bill were benighted and ill-fated at inception and had to be struck down as null and void. As to the cross appeals, I am in full agreement that both of them should fail, and that's my position. And so, finally, in conclusion, I would express my deep gratitude to all counsel and parties who appeared before us. The depth and extent of learning that went into the preparation of these appeals and cross appeals by both sides of the divide was truly impressive. The authorities were numerous and the workload quite daunting, and I must commend the industry and commitment on display before us. The erudite submissions made passionately and with persuasive force exemplified the importance of oral advocacy at the bar by both seasoned seniors and talented young legal eagles. The latter exemplified Chinua Achebe's quip in Things Fall Apart that when a child washes his hands, he gets to eat with kings. These young lawyers will soar to great heights, and should they maintain the discipline, hard work, courtesy, and professionalism that was in prodigious display before us, there is reason for optimism that the future of the profession is safe despite present troubles. As the cases, textbooks, articles, commentaries, and other authorities were in their scores, running into hundreds, nay, thousands of pages, it was not possible to refer to each and every one of them, just as it was not practical to quote verbatim all the submissions made before us for days, not to mention the hundreds of pages of the same in writing. My not having referred to any of them is no indication of their lack or worth or importance, but merely the function of limited space and time. In the end, I trust that we have all kept the Constitution safe and secure on this occasion, and may it always remain so. Thank you.
Well, thank you, my brother Justice Kiage. It is now about 10 minutes to 5, so we'll take 10 minutes health break, then come and finalize the remaining judgments.
in the promulgation of the Constitution of Kenya 2010. The people of Kenya. Thank you, President, for the opportunity. I will just highlight portions of my judgment and avoid repeating what I agree with my colleagues or what my colleagues have already covered. Today in the history of the nation of Kenya, the constitution review process had successfully culminated in the promulgation of the Constitution of Kenya 2010. The people of Kenya were ecstatic that in the Constitution they had exercised their sovereign power and determined their present and future. It was hailed as one of the most progressive and transformative constitutions. However, the acid test is in the implementation of the Constitution. This is demonstrated in the consolidated appeals before us, where we are called upon to interrogate the implementation of the amendment provisions in the Constitution as provided under Chapter 16 of the Constitution. The consolidated appeals before us arise from consolidated petitions that were filed in the High Court challenging the exercise of these provisions. My brother, President Musinga, has already given that background, and therefore I will not go into it. The issues that were raised in the appeals are many, and as I've already explained, I will just focus on the areas that I have some arguments which differ or which are approaching the issue differently from the others. And so I will add my voice on a few select issues. This is the basic structure doctrine and its applicability to Kenya, the remit of a popular initiative under Article 257 of the Constitution, the legality of the BBI process and the President's involvement, and the propriety of the proceedings against the President. I will not go into the submissions because that has already been done by my colleagues. So I'll go straight to the issue of the basic structure. What is the basic structure doctrine? In my earlier portions of the judgment, I had referred to definitions by Professor Yaniv Rosnai, Professor Beatrice Conrad, Professor Ben Obweze, and also the way it was explained in the Kasavananda case. And drawing from these definitions, I think that simply put, the basic structure doctrine is a principle according to which the power to amend a constitution is expressly or impliedly limited to constitutional amendments that do not alter or change the basic structure of a constitution. In India, the doctrine has been applied as limiting the amendment power of Parliament to alter or change the basic structure of the Constitution. Beatrice Conrad made reference to any amending body organized within the statutory scheme. And Professor Yaniv Rosnai extends the limitation to the exercise of constitutional legislative power and expresses the view that amendment power is sui generis, as it is neither a pure constitutional power nor an expression of original constituent power, and that it is an exceptional authority, yet limited. There are two propositions from these definitions. First, that a constitution has a basic structure. And second, that amendment of the basic structure by any amending body under the Constitution is not permissible if it will substantially alter or destroy the basic structure or identity of that Constitution. And consequently, a limitation on the power to amend the basic structure will be inferred. The latter is the basic structure doctrine. The challenging in considering whether the basic structure doctrine applies to a constitution is to unpack this basic structure in relation to the Constitution. In other words, What is the basic structure in reference to that Constitution? How does one identify the basic structure of the Constitution so as to come to the conclusion that the intended amendment will alter or change that basic structure, such as to bring the basic structure doctrine into play? The general complaint that has been leveled against the judgment of the High Court in regard to the finding at paragraph 474F, which I have quoted in my judgment, but which I will now not read. The general complaint is that the foundational structure described by the judges as covering preamble, the 18 chapters, and the 6 schedules of the Constitution essentially means that the basic structure covers the whole Constitution. To use Ugandan Chief Justice Katurebe's illustration, which he gave in the Mabarizi appeal, the description of the High Court would not only include the foundation, the pillars, the walls, and the trusses, but even the roof, the doors, and the windows. A strict interpretation of the basic structure doctrine with this understanding of the basic structure would mean that the basic structure of the Kenya Constitution would literally consist of the whole Constitution. And therefore, it would be saying the whole Constitution cannot be amended in a way that alters or changes the Constitution. Indeed, the honorable judges of the High Court were of the view that such an amendment can only be done through the exercise of the people's primary constituent power. In my judgment, I have examined what Professor Nobweze says on sovereignty and the exercise of primary constituent power, and I've also looked at the adoption by Ringera J. in the Njoya's case of what Professor Nobweze says. And I'm in agreement that the people, in exercise of constituent power, can abrogate their constitution or make a new constitution, and that the exercise of that constituent power demands the participation of the people through civic education, public participation, constituent assembly debate, consultation and public discourse, and finally a referendum in which the people endorse the new constitution or the abrogated constitution. This is the exercise of the primary constituent power as explained by Professor Nobweze, Professor Rosnai, and applied by Justice Ringera. As defined by Professor Rosnai, primary constituent power is distinct from secondary constituent power. The latter is what Ringera J. addressed in considering whether Parliament had powers under Section 47 of the former Constitution to make amendments that would result in the repeal or abrogation of the Constitution or the enactment of a new Constitution. In this regard, Ringera J. was categorical that Parliament has no such powers. Ringera J. concurred with the position in the Kasavananda case that Parliament has no power to amend or change the basic features of the Constitution or abrogate and enact a new one. And I'm in agreement with this position, which is a position that was adopted by the learned judges in the High Court. However, it is important to note that Ringera J. did not address the exercise of secondary constituent power in regard to an amendment initiated by public initiative, as the Constitution, as it was then, did not provide for it. In my view, the people can exercise their sovereignty in constitution making through their secondary constituent power by either delegating to Parliament or reserving to themselves the power to amend the Constitution. This is what the framers of the Constitution did in Articles 255 to 257 by delegating the power to Parliament to amend the Constitution under Article 256, Subarticle 1 to 5, through a parliamentary initiative and allowing the people to exercise their reserved powers to amend the Constitution through a popular initiative under Article 257. This means that the popular initiative is a citizen-driven process. In both instances, the people remain involved in both the popular initiative and parliamentary initiative through public participation and are the ultimate determinant through the referendum process on whether the amendment is carried. The Constitution of Kenya 2010 also empowers Parliament to exercise constituted power under Article 94(3) of the Constitution in regard to amendment of constitutional provisions other than those mentioned in Article 255. It is necessary to interrogate the express constitutional provisions that donate amendment power so as to determine the extent of the powers provided, especially as relates to the amendment of the basic structure. The starting point for such an interrogation must be an understanding of amendment of the Constitution and a distinction between amendment and dismemberment or change and remaking of a Constitution. In the judgment, I have looked at several definitions of amendment and dismemberment, and from these definitions, it is clear that an amendment is an alteration of the Constitution that is carried out within the confines of the existing Constitution. Secondly, it alters the Constitution in a way that does not radically change the nature of the Constitution, which means it must remain consistent with the object of and the purpose of the Constitution. This is to be contrasted with change or remaking of the Constitution, which involves a complete review and/or substitution of the former Constitution with a new one, and this can only be done through the exercise of primary constituent power. Therefore, dismemberment in regard to Constitution would mean completely tearing the Constitution apart by removing its significant parts so that it no longer has the same identity. This is more drastic than amendment. I bear in mind these definitions and distinctions as I proceed to consider the amendment power. As noted in the judgment of the High Court and the respective submissions that were made before us, the history of Kenya in regard to amendment of the Constitution is replete with abuse of the amendment provisions and a hyper-amendment culture that resulted in the mutilation of the former Constitution. In truth, the amendments culminated in dismemberment of the original Constitution. It is in that context that Chapter 16 of the Constitution was made and must be understood. The framers of the Constitution no doubt wanted to make sure that a situation does not arise where the amendment provisions are abused in a way that results in dismemberment. Dismemberment of the Constitution or negates the spirit and purpose of the Constitution. Nonetheless, they incorporated a specific chapter in the Constitution dealing with amendment of the Constitution, leaving no doubt that they accepted the fact that there will be situations in which there will be need to amend the Constitution. The amendment provisions in Chapter 16 were made with abundant caution, as Article 255 provides not only for amendment of the Constitution to be made either through Parliament or through a popular initiative, but also provides a higher threshold for amendments relating to certain thematic areas of the Constitution. The thematic areas have been identified in Article 255, and I have reproduced them in my judgment. I will not go through them now. But it appears to me that the framers of the Constitution, either consciously or unwittingly, identified the basic structure of our Constitution through Article 255. In my view, the thematic areas that have been identified are crucial and form the pillars of the Constitution. For example, without the thematic areas of the supremacy of the Constitution, the territory of Kenya, and the sovereignty of the people, the document would not have its identity and would be a completely different document from what was envisaged by the people and the framers of the Constitution. Without the national values and principles of governance, the Bill of Rights, and the independence of the judiciary, the Constitution would be a hollow document, not protecting the rights of the people or serving the interests of the people of Kenya as was intended. That is to say, that the framers of the Constitution of Kenya 2010, conscious of these thematic areas as the main pillars forming the basic structure of the Constitution, nonetheless provided a leeway for amendment of these thematic areas, putting in place appropriate safeguards, including the people's participation and final decision on the amendments. This is a clear indication that in regard to amendments, the Constitution of Kenya 2010 is explicit and self-sufficient. The key question in considering whether the basic structure doctrine applies in Kenya is whether, notwithstanding the express provisions for constitutional amendment contained in Chapter 16 of the Constitution and the limitations imposed therein, additional implied conditions that limit the amendment power can be inferred relying on the basic structure doctrine, and whether there are any eternity clauses or provisions of the Constitution that are unamendable. As my brother Judge Gatembo stated, the concept of a basic structure is not a new concept in our jurisdiction. Like him, I have also identified a few cases where this concept was discussed by the courts. And from the submissions that were made before us, it is clear that the issue of constitutional amendments is a topical issue that has elicited opinions, debates, and scholarly writings from jurists and academicians. It has also been subject of litigation in several jurisdictions. In discussing constitutional amendments, the paradox of unconstitutional constitutional amendments has come to the fore. Like the opinion of doctors, the opinion of legal experts is divided, some in agreement, others in disagreement. Legal and academic writers in the academic discourse give us theory of what the ideal constitution should look like and what should be the aspiration in making the constitution. But constitutions are like human beings. They are never perfect. Each constitution responds to different circumstances in a social setup that is not necessarily the same as another. Constitutions cannot therefore be the same. Many times, as happened during the constitutional review process in Kenya, compromises and concessions have to be made in order to arrive at an agreement. Furthermore, although the people make the constitution with assistance from experts, the views of experts, important as they are not always followed. These are all important factors in the interpretation of the Constitution. Amendment of constitutions are often necessary to respond to situations or changing circumstances in the particular society. Likewise, the framers of the Constitution of Kenya 2010 recognized the need for development of the Constitution and provided for it in Article 259. This article obligates an interpretation of the Constitution in a manner that not only promotes its purposes, values, and principles, but also advances the rule of law, the human rights and fundamental freedoms, and permits the development of the law and contributes to good governance. Thus, the Constitution must be interpreted in a balanced way that achieves all these aims. As already noted, Article 255 provides a limitation to the amendment power in the identified thematic areas. It provides a higher threshold for alteration of any part of the basic structure identified in Article 255. Such amendments can only be done within the constitutional boundaries so that the amendment does not distort or deviate from the original purport of the Constitution. Under Article 257, the people can call in their reserved secondary constituent amendment powers through a popular initiative. But the exercise of that power must remain subservient to the Constitution because it is a power that, unlike the primary constituent power, emanates from the Constitution. The amendment must serve the Constitution to the extent of developing it without deviating from its original purport. The amendment must remain faithful to the Constitution. The exercise of the secondary constituent power under Article 257 of the Constitution through an amendment by a popular initiative is not inconsistent with the basic structure doctrine, though slightly different from the application in India, to the extent that the power is expressly provided for in the Constitution, and the amendment initiative neither originates from Parliament, nor does Parliament have the final say. The amendment process provided at Article 257 is inclusive, as it not only involves the people in its initial stages, but also provides room for participation of Parliament and the National Assembly, and the people retain the power of approving the final product at the referendum. It is therefore an amendment that is done by the people, but with a limitation that, being a secondary constituent power, it is subservient to the primary constituent power and must remain true to the original purport of the Constitution. At paragraph 47G, permit me just to read just a little to put the whole thing in context. The learned judges of the High Court stated that there are certain provisions in the Constitution which are inoculated from any amendment at all because they are deemed to express categorical core values. And these provisions are therefore unamendable. These provisions can also be termed as eternity clauses. And then they say an exhaustive list of which specific provisions in the Constitution are unamendable or are eternity clauses is inadvisable to make in vacuum. The learned judges go on to give Article 2.1 and 2.5 as examples of unamendable clauses or uneternity clauses. But according to Professor Rosnai, unamendable provisions limit the holder of the constitutional amendment power in exercising its power to certain constitutional subjects, principles, or institutions. Professor Rosnai also posits that unamendable provisions may also generally protect the spirit of the Constitution, spirit of the preamble, fundamental structure of the Constitution, or nature and constitutional elements of the state. The Constitution of Kenya has not specifically identified any particular clause as an unamendable clause or an eternity clause. Therefore, as admitted by the learned judges, there are no express eternity clauses or unamendable provisions in the Constitution. However, as already noted, there is restriction of amendment power in Chapter 16 of the Constitution, such that under Article 255 to 257, there are procedural and substantive limitations to the amendment power, so that amendments involving the specific thematic areas can only be done if there is compliance with the strict procedures provided. It cannot be said that the provisions in the thematic areas are unamendable because the Constitution has provided for amendability subject to the limitations indicated in Chapter 16. The question is whether, as contended by the learned judges, there are certain provisions in the Constitution that are inoculated from this amendment power because they express core categorical values. As there is no express provision for unamendability, is there justification for the conclusion by the learned judges that some provisions of the Constitution are unamendable? While I disagree with the learned judges' position that there are unamendable clauses in the Constitution, I find the argument by Professor Rosnai that there may be a general implicit unamendability that runs through the Constitution to protect the original purport and spirit of the Constitution persuasive. This is consistent with the sentiments expressed by the learned judges in two of the cases that were relied upon by the judges of the High Court, and which I have reproduced in my judgment for purpose of clarity. But I will just mention them here. There was the United Democratic Movement versus Speaker of National Assembly and others, which is a South African case, and which they talk about the preamble to our Constitution is a characteristic task but profound recordial of where we come from, what aspirations we espouse, and how we seek to realize them. And then it goes on, but I will not read it. Then similar sentiments were also expressed by the Tanzania Court of Appeal in Dianabo versus the Attorney General, where they said, among other things, that the Constitution of the United Republic of Tanzania is a living instrument having a soul and a consciousness of its own, as reflected in the preamble and fundamental objectives and directive principles of state policy. In interrogating the original purport and spirit of our Constitution, my first port of call is the preamble to the Constitution, which I have reproduced in my judgment, but I'll not read in the interest of time. The preamble indicates that the Constitution is the exercise of the sovereignty of the people of Kenya in determining their form of governance to meet their aspirations for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. It also shows their commitment to nurturing and protecting the well-being of the individual, the family, communities, and the nation. It also shows the sustainment of their heritage, their commitment to sustainment of their heritage and environment for their benefit and that of future generations, and the fostering of peace and unity as one indivisible sovereign nation. These aspirations and objectives are the purport and spirit of the Constitution that must remain alive in the implementation of the Constitution. The exercise of any legislative power to enact an amendment that is contrary to the purport and spirit of the Constitution will not pass muster. That is to say, that although all the core parts of the Constitution are amendable under Chapter 16 of the Constitution, there is an implied limitation that amendment of the Constitution will only be permissible if compliant with the purport and spirit of the Constitution. In this regard, I respectfully disagree with the position taken in the decision in the South African case of KwaZulu-Natal and others versus President of the Republic of South Africa, where it was stated that the reliance upon the spirit of the Constitution is misconceived, and that once the procedure in the amendment process is adhered to, the amendment is constitutionally unassailable. I disagree with that. In my view, any proposed constitutional amendment must pass muster in both the procedural and substantive tests. Accordingly, the fact-intensive determination that was adverted to by the High Court should not be one to determine the unamendability of any particular constitutional clause or core parts of the Constitution, but a substantive examination of the purported amendment in order to determine whether the amendment meets the substantive test in regard to the spirit and purport of the Constitution as revealed in the preamble. This is the threshold of the general implied unamendability that would render an amendment an unconstitutional amendment if it does not meet the substantive test. This can well be illustrated by the examples that were given by the first to fifth respondent at paragraph 282 of their petition that was filed in the High Court. For instance, an amendment to Chapter 2 of the Constitution to divide Kenya into two would fall into the thematic area of supremacy of the Constitution and would be contrary to the people's determination as espoused in the preamble to live in peace and unity as one undivided nation. Secondly, an amendment of Chapter 10 to abolish the judiciary would be contrary to the aspirations of Kenyans for a government based on essential values of justice and the rule of law. Another example, an amendment of Chapter 4 to abolish the right of an accused person to a hearing would be contrary to human rights, justice, and the rule of law. An amendment of Chapter 1 to relinquish control over Kenya to Uganda or any foreign power would be contrary to the people's sovereign power and their determination to live in unity as one indivisible foreign nation. So the examples are purported amendments that touch on the basic structure of the Constitution as identified through the thematic areas stated in Article 255, Subarticle 1 of the Constitution. The purported amendments may meet the procedural strictures provided under Chapter 16 of the Constitution, but would not meet the threshold of the general implied unamendability in regard to the spirit and purport of the Constitution as revealed in the preamble. It is also instructive that the preamble to the Constitution is not a constitutional clause that can be amended. It's an introductory statement which remains the reference point in terms of the Constitution's aims and objectives. It is therefore what I can describe perhaps as the GPS from which each constitutional clause gets direction, and any amendment must be measured accordingly. So with all that, my finding on the basic structure, rather my conclusion on the basic structure is, first, that the Constitution of Kenya has a basic structure which has been identified by way of thematic areas in Article 255, Subarticle 1 of the Constitution. Secondly, Chapter 16 of the Constitution provides for amendment of any part of the Constitution, including the basic structure, and no express and amendable constitutional provisions or eternity clauses have been provided in the Constitution. And finally, the basic structure doctrine is applicable in Kenya to the extent that the exercise of secondary constituent power and constituted power to amend the Constitution is impliedly limited by the Constitution as evident in its spirit and purport, and therefore the exercise of amendment powers under Chapter 16 of the Constitution is impliedly limited, as such amendment must conform to the spirit and purport of the Constitution. Now, turning to the meaning and purport of a popular initiative under Article 257 and its constitutional remit, Article 257 of the Constitution provides for an amendment by a popular initiative. I've quoted that section, but I'll not read. In addressing the power to amend the Constitution through a popular initiative under Article 257, the first question that arises is, what is an initiative, and who is a promoter in regard to a bill under this article? The High Court was criticized for relying on the definition from Wikipedia, a free online encyclopedia created and edited by volunteers. On my part, I have sourced the definition from Black's Law Dictionary, 11th edition, in which initiative has been defined. And that definition, which I will not read in the interest of time, that definition concurs with the Wikipedia definition which the High Court adopted. So, in other words, their reliance on Wikipedia was inconsequential. From the above definition, it is apparent that an initiative is a process through which voters take control by compelling a vote on a specific legislation. This means that the process must be a process initiated by a voter or voters as opposed to their representative. The definition is consistent with Article 257 that requires a promoter of the bill to galvanize support for it and establish that it is supported by at least 1 million registered voters. The definition is also consistent with Article 1, Sub-Article 2 of the Constitution that provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, I've also looked at the American equivalent of which is referred to as the American equivalent of a popular initiative, which is referred to as a constitutional initiative. And this is how Professor Albert Stern describes it. The constitutional initiative is a technique of constitutional reform which affords a means of supplementing amendment by legislative proposal. It is not intended to replace the older method of altering state constitutions, but merely to provide an instrument whereby the people acting directly may inaugurate change. It continues, but I'll not go on. Then, looking at the history, we see that in the final report of the Technical Working Group of the Constitution of Kenya Review Commission, which was quoted by the Attorney General on the historical background, it reveals the same thinking, because it was stated that the committee introduced a novel idea called popular initiative, and this is an innovation where the citizen can, on their own motion, initiate amendment to the Constitution by a way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. So the framers of the Constitution, having provided under Article 256 for a parliamentary initiative, it follows that the second avenue of a popular initiative was intended for the people and not their representatives, such as members of parliament or the president. The word promoter has been used in Article 257, 3 and 4, where the promoter is obligated, respectively, to formulate a general suggestion into a draft bill and to deliver the draft bill and the 1 million supporting signature to IEBC. Black's Law Dictionary has defined a promoter, and I've quoted that definition. And using that definition, a promoter of a popular initiative under Article 257.3 may not necessarily be the originator of the idea of a popular initiative, but one who takes the lead in putting the idea together in the form of a bill and encouraging other voters to support the idea. In line with the objective of a popular initiative, such a promoter must be an ordinary citizen and not a parliamentarian or a state officer. So my finding on the popular initiative is that I concur with the learned judges of the High Court that a popular initiative is an initiative of the ordinary citizenry as opposed to the law-making bodies, and that it is intended to be used where the law-making bodies are unable or unwilling to act. Neither the President nor any state organ can initiate an amendment through a popular initiative under Article 257. Another issue is whether a constitutional amendment through popular initiative calls for public participation. This one, I will not go into it. I think it has already been discussed. The issues and the arguments have been made by my other colleagues, my brother and sister judges who have already given their judgments. And indeed, I come to the same conclusion that there must be participation, and not just participation, there must be meaningful participation. So I'm in agreement with the learned judges that public participation is one of the principles of good governance, and that it's a constitutional right that must be complied with at every stage of a constitutional amendment process. And in particular, I have said that it's particularly crucial at the commencement of a popular initiative, because the people must have appropriate information regarding the initiative to enable them make an informed choice on whether to support the bill or not, on whether to support the initiative or not. And therefore, the adequacy of public participation at the outset is very crucial. For if the people are not well informed and properly engaged, then the initiative cannot be a citizen process. One other issue with regard to participation, the appellants argued that it was for the respondent who are alleging that there was no public participation to prove this fact. However, under Section 112 of the Evidence Act, it is provided that in civil proceedings, when any fact is especially within the knowledge of any party to those proceedings, the burden of proving or disproving that fact is upon that party. If there was public participation carried out in regard to the popular initiative, this was a fact that was within the special knowledge of the appellants who are promoting the Amendment Bill 2020. The appellants cannot therefore shift the blame onto the respondents to prove the fact of public participation. No evidence was laid before the court to prove that there was any meaningful public participation before the collection of signatures in support of the proposed constitutional amendments. And I therefore uphold the finding of the learned judges that the BBI Steering Committee, as a promoter of Kenya Constitutional Amendment Bill, failed to comply with the key constitutional requirement of giving people information and sensitizing them prior to the collection of signature, and this rendered the process constitutionally unsustainable. With regard to the procedure in the county assemblies and parliament, it has already been referred to by my colleagues, and I concur that the mandate of the county assembly in interacting with the public initiative is only to consider, at that stage, is only to consider and either approve or reject the draft bill. It has no mandate to make any alterations to the bill. On the legality of the BBI process and the President's involvement, the popular initiative leading to the publication of the Constitution of Kenya Amendment Bill 2020, which is what I refer to as Amendment Bill 2020, originated from a process that has become commonly known as Building Bridges Initiative, BBI. This process was commenced through a handshake between His Excellency the President and Honorable Raila Amolo, and it was followed with the appointment of Building Bridges to Unity Advisory Task Force by His Excellency the President, Uhuru Muigai Kenyatta, whom I refer to herein as the President. It is apparent that the President was at the forefront in the facilitation of the BBI process, including the appointment of the BBI Advisory Task Force and the BBI Steering Committee. The Gazette notices were duly signed by the Head of Public Service, confirming that the appointments were made by the President in his official capacity. While the respondents submitted that the President abused his powers in engaging in the BBI process, the appellants asserted that in facilitating the BBI process, the President was exercising his authority under Article 131E, as read with 131(2)(c) of the Constitution, in promoting and enhancing the unity of the nation. And Article 131E states that the President is a symbol of national unity. 131(2)(c) gives him the authority of promoting and enhancing unity. So the process leading to the handshake between the President and Honorable Raila Odinga, the formation of the BBI Advisory Task Force and the BBI Steering Committee, and the consequent amendment bill is, in my view, akin to the National Accord or Peace Initiative that was signed on 25th of February 2008 between former President Mwai Kibaki and his erstwhile rival, Honorable Raila Odinga, with a view to implementation of a reform agenda to bring peace and address the recurrent conflict in the country. As explained in the Kivuitu case, which I've quoted and referred to there, the signing of the National Accord resulted in the former president appointing an independent review commission under the Commissions of Inquiry Act, whose mandate included examining the constitutional and legal framework for the conduct of elections, the organization and management structure of the Election Commission of Kenya, and its capacity to conduct electoral operations with a view to recommending electoral reforms. The Commission presented its report to President Mwai Kibaki on 17 September 2008, in which it recommended fundamental amendments to laws governing conduct and management of elections. The report, commonly known as the Kriegler Report, resulted in the enactment of the Constitution of Kenya Amendment Act No. 10 of 2008, which disbanded and replaced the Election Commission with an interim independent electoral commission. So this particular law was challenged in the Kivuitu case, and that is one case where the issue of the exercise of the presidential power came up also. The learned judges in the judgment and appeal rejected the plea of res judicata and plea of sub judice in regard to the legality of the appointment of the BBI Advisory Task Force and the BBI Steering Committee for the reasons that have been stated by my brother Musinga, President, and I'm in agreement with the learned judges that the doctrine of sub judice did not apply. One of the terms of reference of the BBI Steering Committee published in Gazette Notice number 264 as 1B and reproduced at paragraph 549 of the impugned judgment was, and I quote, to propose administrative policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the task report. And I underline the words propose and the words or. The mandate of the BBI Steering Committee in this regard was first to propose changes. In other words, the committee was to make proposals for change. Black's Law Dictionary 11th edition defines proposal as something offered for consideration or acceptance, a suggestion, the act of putting something forward for consideration. Secondly, the proposed changes were to be administrative, policy, statutory, or constitutional changes. Hence, the mandate was not to make constitutional changes, but to make recommendations on whatever changes that were necessary. The use of the word or indicated that the changes did not necessarily have to include constitutional changes. Thirdly, it was not part of the mandate of the BBI Steering Committee to implement the constitutional changes, if proposed, but to give advice on how such changes should be implemented. Thus, the purported distinction between the BBI Advisory Task Force and the BBI Steering Committee did not exist, as the BBI Steering Committee was not established for the sole purpose of initiating and promoting constitutional changes. Although the Third Way Alliance case related only to the appointment of the BBI Advisory Task Force, the issue raised in that case substantially related to the President's powers to appoint a task force or committee. In that regard, the finding on that issue relates to the appointment of the BBI Steering Committee, which was appointed before that judgment, as much as it relates to the BBI Advisory Task Force. More so, because the mandate of the BBI Steering Committee, as appointed, did not include initiating and promoting constitutional changes. In short, the matter before the High Court regarding the legality of the appointment of the BBI Steering Committee was res judicata and not open for consideration by the learned judges of the High Court. In the impugned judgment, the learned judges of the High Court found that the appointment of the BBI Steering Committee was unconstitutional, as there was no evidence that the President had complied with the provisions of Article 132(4)(a). I have considered these findings against the rival contention that the President was exercising his authority to engender peace pursuant to Article 131. Given the background to the BBI process, as I've already adverted to, the initiative leading to the BBI process was not any different from the peace accord that was signed between President Kibaki Honorable Raila. No evidence was produced to show that the appointment of the BBI Advisory Task Force and the BBI Steering Committee was approved by the Public Service Commission as required under Article 132(4)(a). However, both committees, that is, the BBI Advisory Task Force and the BBI Steering Committee, were ad hoc committees appointed to advise the President. The appointments were actually officially gazetted under the hand of the Head of Public Service, Mr. Kinyua. And I'm in agreement with the position stated by Mativo J. in the Third Way Alliance case that the authority of the President in Articles 131 and 132 of the Constitution ought not to be constrained as long as the exercise of that power is rationally related to the purpose for which the power was given. The President cannot therefore be faulted for initiating the BBI process, appointing the BBI Advisory Task Force and the BBI Steering Committee in an effort to foster unity, which is an initiative that was within his constitutional mandate. Furthermore, Article 256 and 257 provide for amendments by way of a parliamentary initiative and a popular initiative, respectively. These articles provide for the constitutional procedures that has to be followed in procuring the constitutional amendment. They do not provide for proposals for making an amendment by a parliamentary or popular initiative. Obviously, before the drafting and promotion of a parliamentary or popular initiative, a lot of preliminary work has to be done. There is nothing that prevents the procurement and consideration of proposals for amendment by any person. The President was therefore free to obtain proposals for constitutional change from any quarters, including the BBI Steering Committee. Such proposals could have been used in lodging a parliamentary initiative or even a popular initiative by appropriate persons, following the appropriate procedures provided under Article 255 and 257. The BBI Steering Committee, having given its proposals on changes which included a proposed constitutional amendment bill, its mandate was expended at that stage. For these reasons, I find that the learned judges not only erred in considering the legality of the BBI Steering Committee as the issue was res judicata, but also erred in finding that the BBI Steering Committee was unconstitutional and an illegal entity created to perpetuate an unconstitutional purpose. The formation of the BBI Task Force and the BBI Steering Committee all appear to have been done in good faith to achieve that purpose. Constitutional changes by means of an amendment to the Constitution falls under Article 255 and 257 of the Constitution, and there is no provision for the President to initiate proposals for amendment of the Constitution in the name of a popular initiative. While I do appreciate and commend the President's efforts in fostering the unity of the nation, the President is not an ordinary citizen. He remains the President in the political arena throughout his tenure. He cannot temporarily remove his executive mantle in order to engage in a popular initiative, which is a process that has been reserved for citizens. His role in amendment of the Constitution is at the tail end of the process, as provided under Article 2565 and 2579 of the Constitution. And this is, in his capacity as President, to assent to an amendment bill once passed by Parliament or the people through a referendum. It was all well for the President to appoint the BBI Steering Committee and receive the recommendations for legislative and constitutional changes. But having done so, the President ought to have engaged the government machinery or his party in pursuing these changes through the appropriate channel, possibly a parliamentary initiative. As already indicated, BBI was a peace initiative by the President. The appointment of the Advisory Task Force and the Steering Committee included the experts and the drafting team that backed these committees, including the experts and the drafting team that backed these committees, all confirm that BBI was an executive-driven process and not a citizen-driven process. Although I disagree with the finding of the learned judges that the BBI Advisory Task Force and the Steering Committee were unlawful, with their finding that these committees were unlawful, I find that the BBI Steering Committee had no capacity to promote a bill under Article 257. The bill was published as the Constitution of Kenya Amendment Bill 2020. The bill, which was published as a Constitution of Kenya Amendment Bill 2020, was dated 25th November 2020, and the promoters indicated as Building Bridges Initiative. Under Article 257, the promoter of a popular initiative is the one required to formulate it into a draft bill and thereafter deliver it to IEBC with supporting signatures. Dennis Waweru, who described himself as co-chairperson of the Building Bridges to a United Kenya National Secretariat, BBI Secretariat, swore an affidavit in which he claimed that the BBI Secretariat was a mover of the amendment bill and the process intended to amend the Constitution through a popular initiative. Although it was contended that the BBI Secretariat is a voluntary political alliance, there was nothing that was laid before the High Court to confirm this or to establish the existence of the BBI Secretariat or to connect it to Building Bridges Initiative that was indicated on the bill as the promoter. As found by the High Court, the drafting of the Amendment Bill 2020 was done by the BBI Steering Committee and was the culmination of the BBI process initiated by the President. There was no nexus established between the two co-chairs and the BBI process, such as to confirm that the two co-chairs were the promoters of the Constitutional Amendment Bill. In any case, Honorable Junet Mohammed, who is a current sitting member of Parliament, did not qualify to use the popular initiative route. Both the President and Honorable Raila continued popularizing the BBI process and encouraged the collection of signatures in support of the constitutional change proposed through the BBI process. And so the attempt to distinguish the BBI Secretariat as a separate entity from the BBI Steering Committee was not convincing at all and cannot pass. So my finding, the BBI process remained executive-driven, and the promoter of the Amendment Bill 2020 was the President through the BBI Steering Committee. And as a popular initiative is a citizen-driven initiative, the attempt by the President to pursue a popular initiative through the BBI Steering Committee was unconstitutional and unlawful, and to that extent, neither the BBI nor the BBI Steering Committee had the competence to promote the draft Bill 2020. I would therefore uphold the declaration at paragraph 7843 that the President does not have authority under the Constitution to promote a constitutional amendment through a popular initiative, and that a constitutional amendment can only be made through a parliamentary initiative under Article 256 or through a popular initiative under 257 of the Constitution. I would set aside the declaration at paragraph 784, Roman 4, and declare that the BBI Advisory Task Force and the BBI Steering Committee established by the President were not unconstitutional or unlawful entities. I would partly uphold the declarations at paragraph 784, Roman 5, and Roman 6, and Roman 8, to the extent that the BBI Steering Committee, though not unconstitutional or an unlawful entity, had no legal capacity to promote constitutional changes under Article 257 of the Constitution, and consequently, the promotion and launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. So I don't want to repeat. I just want maybe just to highlight a few of my findings on some of the other areas that I have not talked about. On presidential immunity, I have analyzed this in my judgment, but my analysis is substantially the same as what my brother Judge Gatembu has already stated here, so I will not read it. But my finding is that I would uphold the declaration at paragraph 7842 of the judgment and the findings of the learned judges that the President is subject to civil proceedings during the tenure of his office whenever he acts outside the parameters of the Constitution or omits to do that which he is bound to do under the Constitution. And then I would also find on the issue of service upon the President that the President was not served with a petition filed by the 78th respondent, nor was he personally served with a hearing notice. His right to a fair trial and right to natural justice were contravened, and the learned judges were wrong in making adverse orders against him personally. I would accordingly allow Civil Appeal number 294/2021 and set aside the adverse orders that were made against the President in his personal capacity. I'm in agreement with the majority in regard to Each of the issues that I have not fully addressed in this judgment, and for avoidance of doubt, I want to say that I specifically adopt the reasoning and conclusion of the majority in regard to the fact that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the Independent Electoral and Boundaries Commission, that the IEC does not have the requisite quorum for purpose of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill, and that at the time of the launch of the Constitution of Kenya Amendment Bill and the collection and endorsement of signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor an adequate legal/regulated framework to govern the conduct of referendum. That the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null, and void because they were made without quorum and in violation of Sections 5, 6, and 11 of the Statutory Instruments Act. That the county assemblies and parliament cannot, as part of the constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution. That the second schedule of the Constitution of Kenya, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function, is unconstitutional. That is a function of delimitation, is unconstitutional. I am also in agreement on the issues regarding whether the issues before the High Court were moot or not justiciable. I am in agreement with what the President has stated on that. I'm also in agreement on the issue of the amici, and I fully adopt the reasoning of the majority on the cross appeals and concur that these cross appeals should be dismissed. On the issue of whether under Article 257.10 of the Constitution, all the specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions to the people, I am of the view that the Constitution requires that the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. So, in conclusion, I join my brother and sister judges in appreciating the senior counsel and all counsel who appeared before us. The wealth of knowledge, high level of professionalism, and commitment that was displayed by all was prodigious and is commendable. I also recognize the invaluable support that I have received from Irene Chege, my legal researcher, and Harriet Gasheri, my secretary, who worked tirelessly behind the scene to ensure that I had my judgment ready in time. The issues that were raised in this appeal have led to a significant conclusion because it is a practical demonstration of Kenyans' commitment to the Constitution. We, the people, protecting our heritage and determining our future and that of future generations. As custodians of the Constitution, we judges have also risen to the challenge to protect the Constitution from unconstitutional amendments. Ultimately, regardless of the outcome of this appeal, all the parties have won because the Constitution has won. The spirit and purpose of the Constitution remains alive. The final orders shall be as stated by my brother, Musinga, President. Thank you.
Thank you very much, my sister, Lady Justice Okwengu. I will now request my sister, Justice Nambuye, to deliver her judgment.
Thank you very much, Honorable President. The challenge is coming towards almost at the tail end. The issues were common, and what is different is actually the presentations. I think for this reason, I will not go through each and every item arising from the common issues. But may I start by appreciating the leadership of our President. May I adopt the summary that he gave out at the beginning of the deliveries. May I appreciate the brotherhood and the collegiality of the members of the bench who have worked as a team. And the approach I take is because of what I have already mentioned, that the issues were common, and what differs is actually the presentations. I will not go into detail. I will just pick out a few items. The major complaint on why the appellants thought that there is no provision for eternity clauses in our Constitution. Then my own brief comments on that. A brief comment on the constituencies in the amendment bill. Give a few highlights on the principles on legitimate expectation. These were touched upon by my sister, Judge Fatuma Sichale. And then mention briefly on the complaint that had been raised with regard to the need for the trial court to call to the president or the authorities that were responsible for the PPI initiative to give an account of public funds involved. And then in a sentence or so, make a mention on the role of MSI, and then the good work and the industry of the legal minds involved. My first observation on the complaint about the application of eternity on alleged existence is not coming. Hello? Okay. On alleged existence of eternity clauses in the COK 2010, appellants submit
Can we get some assistance?
Thank you. On alleged existence of eternity clauses in the COK 2010, appellants submit that an eternity clause is an actual constitutional provision expressly made in the text of a country's constitution, declaring some provisions unalterable and irrevocable, which clauses are, according to the appellants, aimed at protecting the specific country's provisions of specific purposes. Among examples numerously highlighted were Article 79(3) of the Basic Law of Federal Republic of Germany, which expressly bars amendments to provision concerning the federal structure and to the basic principles laid down in Article 1 and 20 of that institution. And there was also mentioned an example of that the democratic and social setup, owing to the bitter experience of the Nazi era, intended to safeguard against a repeat of the atrocities perpetrated by the National Socialists, and many other examples were given. And my own comments on reaction or my observations is that on the alleged existence of eternity and an amendable clauses in the COK 2010, the position I take is that taken by the appellants, that these do not exist. Reason being that in jurisdictions where these are found to exist, going by the examples highlighted in the appellant submissions, they are expressly provided for in the respective jurisdictions' constitutions. A proper construction of the COK 2010 based on a proper application of the principles for interpretation and construction as highlighted above in the assessment leaves no doubt in my mind that these doctrines have no application in Kenya. That is why the people reserved in themselves the power to amend the COK 2010, which in my view includes the power to overhaul, as they did with the former constitution, or partially amend it subject to compliance with the prerequisites of the amendment power. Second, going by the guiding principles in Article 10 of the Constitution, there is nothing therein to suggest that the Kenyan society will remain static in its lifespan, so as to stick to the value system as obtained at 2010 when the COK 2010 was promulgated. Good prudence would demand that there be constitutional changes which would in turn inform changes in the law to meet societal needs as and when such needs arise. And on the issue of the constituencies as contained in the halted amendment process, I associate myself with what my colleagues have said, but for purposes of the record, I think I have something to say. My comments is that Section 10 of the Impunity Bill proposes to amend Article 89 of the Constitution on delimitation of electoral units to increase the number of constituencies from 290 to 360. The Impunity Bill also attempts to delimit the extra 70 constituencies in violation of Article 89 of the Constitution, violates the principles, procedures, and the safeguards for the delimitation of electoral units. Section 10 of the Impunity Bill, as read with the second schedule thereof, seeks to defeat Article 892 of the Constitution by compelling IEPC to delimit boundaries before the time set by the Constitution and without going through the procedures and safeguards set out in the Constitution. The Impunity Bill also usurps the authority of IEPC to delimit electoral boundaries by providing the number of electoral units to be delimited. This indeed is in contravention of the COK 2010. And I think I will highlight in briefly the principles on legitimate expectation as was held in the Republic versus Kenya Revenue Authority ex parte check distributors limited, civil application number 359. The cornerstone of legitimate expectation is a promise made to a party by a public body that it will act or not act in a particular manner. For the promise to hold, the same must be made within the confines of the law. A public body cannot make the promise which goes against the express letter of the law. Stated simply, legitimate expectation arises, for example, where a member of the public, as a result of a promise or other conduct, expects that he will be treated in one way or the public body wishes to treat him or her in a different way. It is a requirement that for the doctrine of legitimate expectation to be successfully invoked, the expectation must in the first place be legitimate in the sense of an expectation which will be protected by law, and there are various authorities which I have also indicated. In other words, since the doctrine of legitimate expectation is based on consideration of fairness, even where benefit claimed is not procedural, it should not be invoked to confer an unmerited or improper benefit. There are also case law. For the sake of time, the answer, this is in answer to the cross appeal of the 15th respondent. And the answer is in the negative, as PPI's invitation for public input on the policy issues involved made no mention that any requests or recommendations by any participating entity would be taken on its face value. Lack of such an assurance prima facie donated discretion in both the task force and the steering committee to choose what to include in the end product action plan and what to leave out. Stated simply, legitimate expectation arises, for example, where a member of the public, as a result of a promise or other conduct, expects that he will be treated in one way, and the public body wishes to treat him in a particular way. So I agree with my brothers and sisters who have dismissed the cross appeal. I will mention shortly about the complaint on accountability with regards to the publication of the PPI Steering Committee to publish or cause to be published details of the budget and the public funds allocated and utilized in promoting the impugned bill. I associate myself and I agree entirely with the reasoning and the assessment of the judges after construing Article 35 in conjunction with the provisions of Access to Information Act 2016. I find that the cross appellants did not follow the correct procedure to seek that information from the litigants before coming to court to have them enforced in their favor. And I also join my colleagues in commenting the good workmanship, the respect amongst the senior and the junior, and the respect both ways. And I think if we continue this way, we are going to put the legal profession here on the world map. I had never experienced such calmness, such respect for the 44 years I have been on the bench. Thank you, Mr. President.
Thank you very much, my sister Justice Nambuye, for your good summary. Now, for purposes of record, I want to say that I carefully summarized all the submissions that were made before this court by all the parties, and I will not read that. And I identified 21 thematic issues, which I will just read them and give you my brief views on each, after which I will then deliver the final orders of the court based on the findings of each one of us. So the thematic areas that I identified and which we have addressed variously in our judgments are as follows. Whether, number one, whether the basic structure doctrine, eternity clauses, and an amendability doctrine applies in Kenya. Number two, who are the initiators and promoters of the BBI initiative? 3, the legality of the BBI steering committee and the BBI task force report in the constitution amendment process. Number 4, whether the proposed amendments as contained in the Constitution Amendment Bill 2020 were by popular initiative and whether there was public participation. 5, whether the President of Kenya can initiate the process of amendment of the Constitution as a popular initiative. Number 6, whether the IEBC a requisite quorum to carry out its business in relation to the amendment bill. Number 7, the role of the IEBC in constitution amendment by popular initiative. Number 8, whether the IEBC was under an obligation to conduct a nationwide voter registration exercise and the verification of signatures. Number 9, whether the proposals contained in the Constitution Amendment Bill are to be submitted as separate and distinct referendum questions. Number 10, whether the High Court had jurisdiction to entertain the petitions on account of the principles of justiciability, mootness, and ripeness. Number 11, whether it was constitutional for the promoters of the amendment bill to create 70 constituencies and allocate them. Number 12, whether there was necessity for legislation or legal framework on conduct of referenda. Number 13, whether civil proceedings can be instituted against a sitting president. Number 14, whether Mr. Muigai Uhuru Kenyatta, as he was named by Mr. Oluchier, was served with the petition number E426 of 2020 and the effect of the orders made by the High Court against his person. Number 15, again arising from Mr. Oluchier's petition, whether the proceedings against the President, Mr. Uhuru Muigai Kenyatta, were res judicata. Number 16, whether President Uhuru Muigai Kenyatta contravened Chapter 6 of the Constitution. Number 17, whether promotion of the amendment bill violated Article 43(1)(a) in view of the COVID-19 pandemic. Number 18, whether both or either of the Houses of Parliament were infirmed from considering the amendment bill in view of the Chief Justice's advisory for dissolution of Parliament. Number 19, whether the High Court erred in finding that the BBI task force did not create a legitimate expectation that the submissions by KNUN would be incorporated in the amendment bill. Number 20, whether the petitioners had made out a case for disclosure and publication of the BBI steering committee's financial information. And lastly, whether the High Court erred in law in admitting Amishi Kuria who were partisan. So as I indicated, I will not go into the submissions at all. I'll make a few comments on those issues. On the basic structure doctrine, an amendability theory and eternity clauses and their applicability in Kenya, I had the benefit of reading in draft the elaborate opinion of my brother Justice Kiage on this issue, and I substantively agree with his lordship's views and findings. However, I would like to make just a few additional remarks on the same. Taking into consideration the submissions by all the parties as far as the issue of basic structure is concerned, I do not think that there is any serious contestation that the Constitution of Kenya 2010 has a basic structure. What is not agreed upon are the matters that form the basic structure. The Attorney General, the BBI Secretariat, and the Honorable Raila Odinga argue that what constitutes the basic structure are the entrenched provisions listed under Article 255(1), which says as follows. I will not read what it states. Whereas the appellants and some respondents who support the appeals were of the view that the basic structure of our Constitution is not limited to the above matters, the contested issue is whether the basic structure doctrine limits the amendment power of the Constitution as set out in Articles 255 to 257. Related to that issue, the first to fifth respondents argued that the amendment bill, though styled as introducing various amendments to the Constitution, it actually proposes a dismemberment of the Constitution. And they cited Richard Albert in his book, Constitutional Amendment and Dismemberment. Then I pose a question. What is a constitutional amendment? In their petition, the first to fifth respondents stated, and I quote, constitutional amendments come in two types. They can either be corrective or elaborative. Properly defined, a constitutional amendment is a correction made to better achieve the purpose of the existing constitution. I jump and read another paragraph. A constitutional amendment can also be elaborative. An elaboration is a larger change than an amendment insofar as it does more than simply repair a fault or correct an error in the constitution-making project, but does so in line with the current design of the Constitution. Instead of repairing an error in the Constitution, however, an elaboration advances the meaning of the Constitution as it is presently understood. End of quote. I agree with the first to fifth respondent submission that an amendment corrects or modifies the existing system without fundamentally changing its nature. That an amendment operates within the parameters of the existing Constitution, as stated by Walter Murphy in Constitutions, Constitutionalism, and Democracy, Transitions in the Contemporary World. It follows, therefore, that any amendment that alters the constitutional it follows, therefore, that any amendment that alters the Constitution fundamentally, the Constitution's fundamental values, norms, and institutions cannot pass as an amendment. It is in the nature of dismemberment. In my view, the omnibus constitutional amendment bill that seeks to fundamentally alter certain constitutional pillars of our supreme law, like the concept of separation of powers and the independence of the judiciary, is not an ordinary constitutional amendment. It amounts to a dismemberment of the Constitution. Let me illustrate this closely. Let me illustrate this by closely considering some aspects of the impugned amendment bill. This omnibus bill is titled, A Bill for an Act to Amend the Constitution by Popular Initiative. It contains 74 proposed constitutional amendments. Some of the proposed amendments have the effect of interfering with the concept of separation of powers, which is well ingrained in our Constitution. Article 1, Subarticle 1 of the Constitution stipulates that all the sovereign power belongs to the people of Kenya and shall be exercised in accordance with the Constitution. Thus, sovereign power is delegated to Parliament and the legislative assemblies Thus, sovereign power is delegated to Parliament and the legislative assemblies in the county governments, the national executive and the executive structures in the county governments, and the judiciary and the independent tribunals. This arrangement ensures that these three broad arms of government remain distinct from each other and do not encroach upon each other's functions, but subject only to the usual constitutional and statutory checks and balances. Clause 44 of the amendment bill proposes to create the office of the Judiciary Ombudsman by introducing a new Article 172A, and that proposed clause states as follows. There is established the office of Judiciary Ombudsman. The President shall nominate and, with the approval of the Senate, appoint the Judiciary Ombudsman. The Judiciary Ombudsman shall receive and conduct inquiries into complaints against judges, registrars, magistrates, and other judicial officers and other staff of the judiciary. Sensitize and promote engagement with the public on the role and performance of the judiciary, and C, improve transparency and accountability of the judiciary. It continues, it sets out very many functions. I'll jump the rest. There are a few observations that I wish to make regarding this proposed amendment as relates to the independence of the judiciary. 1. The fact that the Judiciary Ombudsman shall be an appointee of the President entrenches executive control in the Judicial Service Commission and by extension in the judiciary. Under Article 171(2), 4 of the 11 members are appointed by the executive. If the proposed bill goes through, the executive's appointees shall be a total of 5. Number 2, of even greater concern is that the proposed duties and functions of the judiciary ombudsman, whose allegiance is to the president, has the effect of making the holder of that office a terror to judges, magistrates, and all judicial staff. That office shall not only receive and conduct inquiries with the complaints against judges, magistrates, registrars, and all judicial staff, but will also play a critical role in the removal of judges. Clause 41 proposes to amend Article 168(2) of the Constitution so that it will read, and I quote, "The removal of a judge may be initiated only by the Judicial Service Commission, acting on the motion by the Judiciary Ombudsman." End of quote. In passing the 2010 Constitution, Kenyans wanted to have a strong and independent judiciary, but the proposed amendment is the exact antithesis of such a judiciary. If a presidential appointee is empowered to receive and investigate a complaint against judges, craft a motion for the judge's removal, and present it for consideration by the Judicial Service Commission, where he sits as an ex officio member, it is not difficult to discern that in making judicial pronouncements, most judges will be very cautious of going against the will of the president. Otherwise, the president may resort to the use of his or her appointee to initiate removal proceedings of the judge, because he who pays the piper calls the tune. This is an ingenious and subtle clawback to the independence of the judiciary. I highly doubt whether there was any meaningful civic education and public discourse on the issue during the promotion of the impugned bill. Decisional and institutional independence of the judiciary in a democratic state should be jealously guarded, and before any constitutional amendment that is likely to interfere with the same is made, the people must be given an opportunity to exercise their primary constituent power. In the final report of the Constitution of Kenya Review Commission, Clause 13.5.4 at page 209, among the things that the people said about the judiciary are as follows, and I quote, "The independence of the judiciary should be entrenched in the Constitution. 2, the Constitution should ensure that there is no interference in the judiciary by the executive and by politicians." End of quote. If this is not executive interference in the work of the judiciary, then I do not know what else amounts to such interference. Number 5, there seems to be a duplication of mandates between the Judicial Service Commission and the Judiciary Ombudsman insofar as the function to receive and investigate complaints is concerned. Article 172(1)(c) states that one of the functions of the Judicial Service Commission is to appoint, receive complaints against, investigate, and remove from office or otherwise discipline registrars, magistrates, other judicial officers, and other staff of the judiciary in the manner prescribed by an act of Parliament. Without any proposed deletion or amendment to the above provision, the proposed Article 172(a) 3A states as follows, and I quote, "The Judiciary Ombudsman shall receive and conduct inquiries into complaints against judges, registrars, magistrates, and other judicial officers and other staff of the judiciary." These two almost similar constitutional provisions will create parallel and incompatible centers of power, which is not good for the country. There is a possibility of parallel complaints against judges and judicial officers being instituted before the two offices. What would happen if there are if they were to arrive at different conclusions on the question of removal. Turning to the legislature, Clause 29, 32, and 33 of the Amendment Bill proposes to remove the requirement for vetting by the National Assembly of Cabinet Ministers, Secretary to the Cabinet, and Principal Secretaries. Clause 31 proposes to introduce the position of Deputy Ministers whose appointment shall not be vetted by Parliament. There is also the proposal to do away with the pure presidential system and replace it with a hybrid one, where there will be a Prime Minister, Deputy Prime Minister, Cabinet Ministers, Attorney General, and the leader of the opposition, who will also sit in Parliament. The people of Kenya, in promulgating the 2010 Constitution, opted for a pure presidential system, and in my view, the proposal interferes with the concept of separation of powers, as members of the executive will also be members of the legislature. I'll briefly now look at the issue of increase of constituencies as proposed in the Amendment Bill. Under Clause 10 and 74, as read together with the second schedule of this Amendment Bill, the promoters of the bill propose to increase the number of the constituencies from 290 to 360. However, without proposing to delete Article 89(2) of the Constitution, which empowers the IEBC to review the names and boundaries of constituencies, the promoters decided to allocate the proposed 70 additional constituencies to 29 counties, but left it to the IEBC to determine their boundaries. The IEBC protested, and rightly so, saying that it has the exclusive mandate of delimiting constituencies as per Article 89(2). I have no hesitation in stating that the task of review of names and delimitation of constituencies exclusively belongs to the IEBC. The people of Kenya decided that the task of delimitation of boundaries should be handled by an independent commission following the criteria set out under Article 89, 5, 6, and 7 of the Constitution. The task of deciding which county should have extra constituencies should have been handled by the IEBC. Entrusting such a delicate responsibility to persons with declared political interests is tantamount to gerrymandering, which James Rowley describes, and I quote, as the process of dividing political units in ways that deliberately create advantages for incumbents or their political allies by placing voters based on their predicated behavior at the polls in districts that dilute the power, dilute the vote of some voters and consolidate the votes of others. End of quote. In conclusion, on that issue, it is not all the 74 proposed amendments that seek to fundamentally alter the basic structure of the social contract that Kenyans entered into when they gave to themselves the Constitution of Kenya 2010 after decades of political struggle. But the few that I have highlighted point to attempts to alter the fundamental aspects of the basic structure of our Constitution, and that, to me, is constitutional dismemberment. That is why I would agree with the learned judges that it is necessary that we replicate the same procedure that we used to give to ourselves the 2010 Constitution if we have to fundamentally amend certain provisions of the Constitution. Regarding the provisions that have been referred to as unamendable, immutable, unchangeable, unalterable, irrevocable, or eternity clauses, as they have been called, Yaniv Rosnai, who has been quoted before, says this: they serve as a mechanism for limiting the amendment power, but they do not and cannot limit the primary constituent power. He further argues that unamendable provisions are subject to changes introduced by extra constitutional forces, read primary constituent power, assembly of the people, or through judicial interpretation. From the foregoing, I would agree with the learned judges that the basic structure doctrine is applicable in Kenya, and that certain fundamental aspects of the Constitution of Kenya 2010 cannot be amended except through the sovereign primary constituent power of the people. However, I do not think that the alteration of the basic structure must be undertaken through the repeal of the Constitution and promulgation of another, as argued by some of the proponents of the doctrine of basic structure. Any provision that may be found to be part of the basic structure of our Constitution may be amended by the people by exercise of their primary constituent power after civic education, public participation, constituent assembly debate, and a referendum. Chapter 16 only applies to pure amendments of the Constitution that do not alter any feature that forms the basic structure. The Constitution of Kenya Amendment Bill 2020, as structured, violates certain components of our Constitution's basic structure. On issue number 2, who are the initiators and promoters of the Constitution of Kenya Amendment Bill? I will not take much time. I just want to keep and say that the President, in the submissions made before this court, confirmed that he established both the BBI Task Force and the BBI Steering Committee pursuant to the functions and obligations conferred upon him by Articles 131 and 132 of the Constitution. From the foregoing, there can be no dispute that the President was the initiator of the BBI initiative, having established and gazetted under his hand the BBI Task Force and the BBI Steering Committee. I am in agreement with the High Court's finding that the amendment bill was an initiative of the President. On the question of the promoter of the amendment bill, the BBI Secretariat and Honorable Raila Odinga, through their senior counsel, Mr. Otiende Amolo, submitted that the bill was promoted by Honorable Junet Mohammed and Honorable Dennis Waweru, the co-chairpersons of the BBI National Secretariat. The same argument was also advanced by the Attorney General, who added that the BBI Secretariat was a voluntary political alliance of political players in Kenya, distinct from the BBI Task Force and the BBI Steering Committee. After going through all this, I find that there is therefore no dispute that the promoter of the amendment bill was the BBI National Secretariat. Number 3, legality of the BBI Steering Committee and its report, and whether it was a popular initiative. It is evident that one of the major functions of the BBI Steering Committee was to propose, among other things, constitutional changes that were thought necessary for the implementation of the recommendations contained in the BBI Task Force report, and submit a comprehensive report to the government. If this was intended, as it turned out to be, a move towards amendment of the Constitution as a popular initiative, that is where the rain started beating the process. Then I asked the question, what is a popular initiative? It is defined as a process of a participatory democracy that empowers the people to propose legislation and to enact or reject the laws at the polls, independent of the law-making power of the governing body. My sister Justice Okwengu has covered it very well. I will not dwell on the same. From what I have said in pages that I have skipped, I agree with the learned judges that the BBI Steering Committee had no constitutional mandate to initiate constitutional changes under Article 257 of the Constitution, disguised as a popular initiative. This was a move initiated by the political elite, not by the people of Kenya. It was not disputed that the promoters of the amendment bill simply posted English versions. I'm on issue number 4, whether there was public participation in the passage of the bill. It was not disputed that the promoters of the amendment bill simply posted English versions of it on the internet. The appellants did not tell the High Court the number of Kenyans that have reliable access to internet and were able to read and understand the English version of the impugned bill. Article 7.1 of the Constitution says that the national language of the Republic is Kiswahili, while Article 7.2 provides that the official languages of the Republic are Kiswahili and English. Considering that the national language is Kiswahili and all major political gatherings are addressed in Kiswahili, it was dishonest on the part of the promoters to purport to have reached out to the masses by simply posting on the internet the amendment bill in English language. The 76th respondent submitted that according to the 2019 Kenya population and housing census, only 22.6% of Kenyans aged 3 and above use internet, while only 10.4% use a computer. And turning to Article 10, participation of the people must be done in a transparent manner. Transparency is one of the major values and principles of governance that bind all state organs, state officers, public officers, and persons whenever any of them makes or implements public policy decisions. Although more than 1 million registered voters signed in support of the amendment bill, it was not demonstrated that the exercise was conducted transparently. Transparency in this case required that before collection of the signatures is done, proper civic education is conducted where, among others, each of the 74 proposed amendments would be well explained to the people so that they understand and appreciate the ramifications of each of them. Some of the proposed amendments are rather superfluous, and strictly speaking, they ought not to have been proposed as constitutional amendments by the promoters. At best, they could only be proposed as statutory amendments, but were intentionally included in the amendment bill, and appropriate statutory amendment bills drawn by the promoters to act as sweeteners to coax voters into supporting the proposed constitutional amendment bills. An example is Clause 3, which proposes to create a new Article 11A on economy and shared prosperity, and the same reads as follows: that this constitution recognizes the need for an economic system that provides equitable opportunities for all the people of Kenya to benefit from the economic growth in a comprehensive, fair, and sustainable manner. I will not read the rest. Together with the amendment bill, the promoters also drew the Micro and Small Enterprises Amendment Bill, which inter alia proposed to give youth-owned enterprises a 7-year tax break. Another example of a bill that accompanied the proposed constitutional amendment bill was the Higher Education Loans Board Act 1995 to give loanees a grace period of 4 years from the date of completion of their studies and to exempt loanees without a source of income from paying interest on the loans advanced to them. I say this about the amendment, the proposed amendment, and those bills. These are definitely very good and appealing proposals, but anchoring them on the Constitution of Kenya Amendment Bill 2020, that also proposed very far-reaching alterations on the basic structure of our Constitution, was a clear bait to entice the populace, and particularly the young registered voters who are the majority, to support the amendment bill without proper civic education on all the contents of the entire bill. Another issue was raised by the Third Way Alliance, the 19th respondent, who questioned the speed at which some county assemblies passed the amendment bill without any public participation. The County Assembly of Tana River is a classic example. In Abesemi Buere versus the County Assembly of Tana River, Nyakundi J established that the County Assembly of Tana River considered and approved the amendment bill on 23rd of February 2021, whereas it had published in the local newspapers and social media that there would be public hearings and a presentation of memoranda on the bill on 25th of February 2021. The learned judge declared that the resolution to pass the bill was tainted with procedural illegality and was therefore fatally defective and unconstitutional. It is also on record that members of county assemblies, MCAs, demanded and were given car grants of 2 million Kenya shillings each shortly before an overwhelming majority of county assemblies passed the amendment bill, paving way for it to be placed before Parliament under Article 257(7). Whereas it is desirable that MCAs be facilitated in their performance of their legislative work in our county governments, and therefore the car grants may have been lawful, its timing was said to have been deliberately intended to influence them to pass the amendment bill. The Salaries and the Remuneration Commission had previously raised various objections to the car grants, but the Commission suddenly changed its position and gave them a green light to the car grants during the promotion of the impugned bill, the 19th respondent asserted. It was also demonstrated that some senior public servants were deployed to go to their counties to promote and campaign for the support of the amendment bill. In Robert Gakuru and another, this court held that public participation must be real and not illusory, should not be treated as a mere formality because it is a constitutional requirement and must be attained quantitatively and qualitatively. I may add that public participation must be done transparently and in demonstrable utmost good faith without any coercion. All these acts and omissions I have highlighted above amounted to violation of certain aspects of Article 10, in particular participation of the people, inclusiveness, integrity, transparency, and accountability. Amendment of a country's constitution ought to be a very sacrosanct public undertaking, and its processes must be undertaken very transparently and in strict compliance with the country's laws. Deliberate compromise of the process will invalidate even a well-intentioned proposal. As George Washington put it, and I quote, "If, in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way in which the Constitution designates. But let there be no change by usurpation. For though this, in one instance, may be the instrument of good, it is the customary weapon by which free governments are destroyed." End of quote. In view of the foregoing, I find and hold that the amendment bill was not by popular initiative, and though there was a degree of public participation in its development and passing, it was not in accordance with the national values and principles under Article 10 of the Constitution. On whether the President can initiate the process of amendment of the Constitution as a popular initiative, I'll simply say that I hold and find that under our constitutional architecture, the President cannot initiate the process of amendment of the Constitution as a popular initiative. The President's intentions in initiating the process were noble, but the process of its execution was not in line with the Constitution. Whether the IEBC had requisite quorum to carry out its business in relation to the amendment bill, I agree with what has been said by my other colleagues. And I'll just read a few parts of my judgment. It follows, therefore, where a court, having declared a provision of a statute as unconstitutional but does not state the effective date of that declaration, the declaration becomes effective from the date of the judgment unless an appeal is preferred against the decision. Then I look at the case of Isaiah Abiwot Kangoni versus Independent Electoral Boundaries Commission, pronouncements by the Supreme Court on some matters. Then I look at Mwita's decision in Katiba Institute versus Attorney General. And then I say, for these reasons, I would dismiss the Attorney General's challenge to the learned judge's finding that the IEBC lacked the requisite quorum to make decisions connected with the amendment bill. Number 7, on the role of IEBC in the Constitution amendment by popular initiative. Muslims for Human Rights, the 82nd respondent, contended that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place. According to an affidavit filed by the IEBC in the High Court in response to the petition, the IEBC maintains a register of voters that contains biometric data and other particulars of every registered voter. Section 2 of the Elections Act defines the term biometric to mean unique identifiers or attributes including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA, and signatures. The IEBC submitted that a signature is just one of the unique identifiers it can use to verify whether a supporter of the popular initiative is a registered voter. That it also considers the unique identifiers of each registered voter. IEBC has a record of all Form A for each registered voter that contains the signature or thumbprint of a voter, their constituency, county, ward, registration center, surname, other names, identity card number or Kenyan passport number, the date of birth, sex, residential address, contact, telephone, postal address, email, and particulars of any disability a registered voter may have. When the promoters went out to collect signatures of supporters of the initiative, the form of the collection of signatures that they had been given by the IEBC required the supporters of the initiative to also indicate their name, identity card number or passport number, constituency card, ward, county, ward, polling station, mobile number, and so on. These are certainly some of the unique identifiers of a registered voter. A signature or thumbprint is one of them, but is not the only one. People's signature can change with time for various reasons, be it age, injury, or disability of their hands, and so on. And it is therefore unrealistic to say to rely on signatures only to identify registered voters. By use of modern technology, I believe it is not difficult to compare the information contained in Form A of a registered voter with the information captured in the form for collection of signatures of supporters of a popular initiative and determine whether the person is a registered voter. In view of the foregoing, I do not entirely agree with the learned judge's finding that the IEBC's role under Article 257(4) involves both the ascertainment of numbers of registered voters in support of a popular initiative for amending the Constitution, as well as a verification of the authenticity of those signatures. It follows, therefore, that there is no constitutional or statutory requirement for a legal framework for verification of signatures under Article 257(4) of the Constitution. What is required is a legal or regulatory framework for verification of registered voters. I, however, agree with the learned judges that the administrative procedures that were developed by the IEBC are invalid because they were developed without public participation by a commission that did not have quorum. Next issue as voters every month. The register of voters must also be updated from time to time as required under Section 8 of the Elections Act. So I come to the conclusion that I find and hold that there is no constitutional or statutory requirement for the IEBC to carry out a nationwide voter registration before any proposed referendum, but the Commission is under a constitutional and statutory obligation to do a continuous registration of voters in each constituency. I further find and hold that in view of that constitutional and statutory obligation, the IEBC should continually sensitize Kenyans about its role and encourage them to continually register as voters, except at such periods as specified by statute when voter registration should not be done. The next issue is whether the proposals in the amendment bill are to be submitted as separate and distinct referendum questions. A plain reading of Article 257 requires that the proposed amendments be reduced into a bill, which is then submitted to the people in a referendum. What is to be submitted to the people is not a question or questions, it is a bill. However, the IEBC may require the people to approve or disapprove the bill by answering a question or questions, either in the affirmative or in the negative. The IEBC, as an independent constitutional body, has the sole responsibility of conducting or supervising a referendum, and it is up to it to determine how the referendum should be conducted, subject only to constitutional and statutory guidelines. For example, under Section 49 of the Elections Act, the question or questions framed by the IEBC must be approved by Parliament. A bill is a proposed legislation and may contain more than one proposed amendments. As stated by the learned judges, the drafters of the Constitution were alive to the fact that a bill to amend the Constitution may propose different amendments. The bill ought to be subjected to a proper public participation where each and every proposed amendment is explained, debated upon, and well-informed views taken before the people eventually vote on the same. That notwithstanding, it is improper to lump together 74 proposed constitutional amendments in a bill. I do not therefore agree with the learned judges that what is to be subjected to the referendum is a question or questions. It is the amendment bill, but the people are to approve or disapprove of the bill by answering a question or questions as framed by IEBC and approved by Parliament. The next issue is whether the High Court had jurisdiction to entertain the petitions on account of the principles of justiciability, mootness, and ripeness. I have defined, in my view, what those concepts mean. Then I've looked at the jurisdiction of the High Court under Article 165, that the High Court has original jurisdiction to determine the question whether a right of fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. A close examination of the issues raised in the consolidated petitions yields the interpretation that the issues in their very sense are not mere political questions, but are in their very nature constitutional issues requiring the determination by a constitutional court. Going by the nature of the issues raised in the petitions and the jurisdiction of the High Court, as stated above, I find that the issues could only have been determined by the High Court in the exercise of its jurisdiction under Article 165 of the Constitution. In this regard, therefore, the High Court could not have exercised deference as argued by some of the appellants, since, firstly, it had jurisdiction to entertain the consolidated petitions, and secondly, the issues could only have been determined properly and adequately adjudicated upon in a judicial process. That may be perceived by some people as unwarranted judicialization of politics. However, it must be understood that the judicialization of politics in our country is a function of the 2010 Constitution that has in several ways widened the scope of the judiciary and in particular commands judges to defend the Constitution. Whereas judges must exercise judicial restraint appropriately and respect the doctrine of separation of powers, when litigants come to court and claim that any person, whether from the executive or legislative arm of the government, is violating or threatening to violate the Constitution, judges must look into the matter and decide one way or the other. On the issue of ripeness, I have concluded that I find and hold that the petitions were neither moot nor non-justiciable. The petitioners demonstrated that there had been some violation of constitutional values and principles in the way the amendment bill had been developed, had been mooted and processed, and the Constitution was about to be dismembered unless the court intervened. To that extent, the petitions did not offend the principles of ripeness. Whereas the process of amending the Constitution was still ongoing, there was every indication that a majority of county assemblies as well as Parliament were poised to approve the impugned bill, which they eventually did, and thus paved way for a constitutionally flawed referendum. Our transformative Constitution cannot countenance that. Had the learned judges declined to assume jurisdiction on account of the principles of justiciability, mootness, and ripeness, they would have violated their respective oaths of office, which they individually subscribed to. A judge's oath of office requires the judge, among other things, to protect, administer, and defend the Constitution without any fear, favor, bias, affection, ill will, prejudice, or any other political, religious, or any other influence. The learned judges were true to their oath of office. I so find. The next issue is whether it was constitutional for the promoters of the amendment bill to create the 70 constituencies. I dealt with that earlier, and I just conclude to say that in view of the foregoing, I agree with the learned judges that the second schedule to the amendment bill, insofar as it proposed to predetermine the allocation of 70 constituencies, is unconstitutional. Next issue is whether there was necessity for legislation or legal framework on conduct of referenda. The judges, the learned judges held that the Elections Act does not meet the intention of the drafters of the Constitution in recommending that Parliament enacts a referendum act to govern the conduct of a referendum. That notwithstanding, the judges held the referendum may still be undertaken as long as the constitutional expectations, values, principles, and objects are met. I entirely agree. In my view, it is not the absence of an appropriate legal framework that posed the greatest challenge to the amendment bill and the proposed referendum. The political elitism, opaqueness, and lack of transparency that characterized the entire process of the proposed amendment of the Constitution were the greatest impediments. The Constitution, the Elections Act, and the Independent Electoral and Boundaries Commission Act contain broad provisions that can be used to conduct a referendum as long as commitment to adhere to the stipulated principles, values, and statutory dictates is observed. The next issue is whether the civil proceedings can be instituted against a sitting president. This was well covered by my brother, Justice Gatembu. And I'll just say, quote, in a decision, Kenya Human Rights Commission and another versus Attorney General, where I sat with Justice Gatembu and Justice Murgo, the court held, and I quote, "In effect, a plain and ordinary interpretation of Article 143(2) would infer that the President's immunity is limited to proceedings instituted during his or her term in office, and 2, to anything done or not done in exercise of the President's powers under the Constitution. Put differently, the immunity does not extend to acts or omissions that have or that were not." Sorry, let me take that again. "To anything done or not done in the exercise of the President's powers under the Constitution. Put differently, the immunity does not extend to acts or omissions that have resulted in civil proceedings commenced prior to assumption of the office of the President, or that were not in exercise of the President's powers." I'll skip the rest of the quotation. "I have not been persuaded to hold otherwise. The President of Kenya does not enjoy absolute immunity against civil proceedings during the tenure of office, and neither is the President above the law. He is subject to the Constitution. However, no civil proceedings can be instituted against the President during the President's tenure of office if the complaint is based on any act or omission of the President in the exercise of the powers conferred upon the President by the Constitution. If the President, in his or her own private capacity, not in the exercise of the President's constitutional powers, were to do anything against a person's private rights, that person would have liberty to file a civil suit against the President in his personal capacity during the tenure of office of the President. But if the President, in exercise of powers conferred by the Constitution, does or fails to do anything that is alleged to be contrary to the Constitution or statute, civil proceedings can only be instituted against the President when his or her term comes to an end." Going back to the issue number 14, was the appellant, the President, Mr. Uhuru, was the appellant, Mr. Uhuru Kenyatta, afforded a fair hearing? To answer this question, I shall consider whether the appellant was served with the petition number 426/2020 and a hearing notice, and therefore are given an opportunity to be heard. Rules of natural justice require that every person must be accorded a reasonable opportunity to be heard before an adverse decision is made against them. If that is not done, any resultant decision that aggrieves the person is a nullity, as was held in Onyango Olo versus Attorney General. Counsel for the appellant submitted that there was no service of the petition upon their client. The petitioner, Isaac Aluchir, filed an affidavit of service dated 16 January 2021, in which he stated that he electronically served the appellant as it was impossible to effect personal service upon him. The email address he used was cos@president.go.ke. The record of appeal shows that on 21st of January 2021, the trial court directed, and I quote, all petitions in the 7 petitions to serve the petitions on all the other parties by close of business on 22nd January 2021. The Deputy Registrar to facilitate the process where necessary. The respondents, interested parties, and amici to file their respondents to the various petitions within 14 days of tomorrow. Then the record, I've looked at what it shows. It kept on showing that the first respondent, who was named in his personal capacity as Mr. Uhuru Kenyatta, was unrepresented. So I proceed and make the conclusion that, but assuming the email address that I have read is the official one of the Office of the President or State House, the petitioner did not demonstrate that it was proper to sue the President in his personal capacity, but purport to effect service upon him through the official email address of the Presidency. In my view, the petitioner should have sought leave to effect substituted service by way of advertisement in the local newspapers if he could not get the personal email address of the President. Considering the kind of orders that were being sought against the appellant and the effects of grant of the same, the trial court ought to have been satisfied that there had been proper service of court process upon the appellant. I find and hold that there was no proof of service of the petition and the hearing notice upon the appellant. The appellant's constitutional right to a fair hearing as guaranteed under Article 50 of the Constitution was violated in that he was condemned unheard. Consequently, all the orders made against Mr. Uhuru Muigai Kenyatta, as named by Mr. Olucher in his personal capacity, cannot stand. I would therefore set aside the declaration made by the High Court that Mr. Uhuru Muigai Kenyatta contravened Chapter 6 of the Constitution. Next issue whether the proceedings against Mr. Uhuru Muigai Kenyatta res judicata. I proceed to make the conclusion that, on my part, I cannot fault the findings made by the learned judges. I agree with them that the issue as to whether the President could establish a committee to initiate a change or amendment of the Constitution outside the remit of Articles 255 to 257 of the Constitution had not been raised in the earlier petition. The learned judges were therefore bound to hear and pronounce themselves on that important issue. The next issue is whether the Constitution Amendment Bill 2020 violated Article 43(1)(a) in view of the COVID-19 pandemic. Article 43(1)(a) states as follows, and I quote, "Every person has the right to the highest attainable standard of health, which includes the right to health care services, including reproductive health care." Mr. Omoke argued that the President was in total violation of the Constitution when he authorized or used public funds to initiate and promote the impugned bill amidst the COVID-19 pandemic. His argument was twofold. First, that since the country was and is still engulfed by a pandemic that poses a serious health challenge to all, the state should have prioritized the fight against the spread of COVID-19 virus by allocating sufficient resources rather than engaging in political activities. Secondly, the President and his agents, by organizing or attending what he termed as, I quote, massive super spreader events, including rallies and signature collection to promote the BBI agenda amidst the COVID-19 pandemic crisis, was a violation of Article 43(1)(a). It was also in disregard of the COVID-19 directives and regulations issued by the President himself and the Ministry of Health, banning public gatherings, maintenance of social order, and putting on masks, Council added. My conclusion on the matter is that while I agree that holding public rallies that are attended by thousands of people militates against COVID-19 mitigative measures, there was no empirical data or scientific evidence provided to the learned judges to enable them make a determinative finding that the holding of the said events per se amounted to a violation of Article 43(1)(a) of the Constitution. And regarding the amounts that were spent, my conclusion is that I find that there was no sufficient evidence to enable the learned judges reach a finding that the expenditure amounted to a constitutional violation. I will therefore dismiss that ground of the cross appeal. Next issue is whether both or either of the Houses of Parliament were infirmed from considering the Constitution Amendment Bill in view of the Chief Justice's advisory for the dissolution of Parliament. I have found that there were orders that were issued by Justice Korir in several matters. The High Court observed that it was in the public interest not to subject the country to parliamentary elections before exhaustively interrogating the constitutionality of the advisory by the Chief Justice, and that public interest supported the issuance of an order suspending any decision to dissolve Parliament. The amendment bill was tabled before the National Assembly and the Senate on the 4th of March 2021 for the first reading. A vote on the amendment bill was taken in both houses on 6th and the 11th of May 2021, respectively. As at the date of tabling and voting on the amendment bill, the orders issued by the High Court suspending the implementation of the advisory by the Chief Justice were still in force, and there was no indication that the orders had been vacated. Accordingly, none of the Houses of Parliament was informed from considering any of the from considering and or debating the amendment bill, owing to the advisory opinion by the Chief Justice. Next issue is whether the High Court erred in finding that the task force did not create a legitimate expectation on the submission by KNUN that it would be incorporated in the Constitutional Amendment Bill. I've looked at that, and my conclusion is that there is no demonstration. Sorry. In this regard, the fact that the proposals by KNUN were not incorporated in the amendment bill cannot be a basis of invalidating the amendment bill. It was not demonstrated that it was only the proposals by KNUN that were not incorporated in the amendment bill. For these reasons, I would dismiss the appeal by KNUN. Number 20, whether the petitioners had made out a case for disclosure and publication of the steering committee's financial information. I have considered what Mr. Morara said in that cross appeal and come to the conclusion that there is no demonstration at all by Mr. Morara that he requested for any information from the President, Honorable Raila Odinga, and the BBI steering committee regarding the budget and public funds allocated and utilized in promoting the impugned bill. The learned judges cannot therefore be faulted for declining to issue their aforesaid orders. Consequently, I would dismiss Mr. Morara's cross appeal on the issue. And the last one is whether the High Court erred in admitting Amishi Kuria, who were partisan. My conclusion is that, in my view, there is no evidence that the Amishi who were admitted to the High Court proceedings were biased. Their respective briefs were of great assistance to the learned judges in determining the issues I have alluded to. Although the Amishi were not parties to the High Court matters, having been admitted in the proceedings in that limited capacity, in the appeals, the first appellant named them as respondents, and therefore they had to file submissions in reply. I must add that I found the submissions quite useful in this appeal. Disposition. Having determined all the issues that we considered germane in these consolidated appeals, the final orders of the court are as follows. A, we uphold the judgment of the High Court to the extent that we affirm the following. 1. The basic structured doctrine is applicable in Kenya. Sichale J.A. dissenting. 2. The basic structure doctrine limits the amendment power set in Articles 255 to 257 of the Constitution. Sichale J.A. dissenting. For you. Yes. Okay. Sorry, I take this back. 2. The basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. Okwengu J.A. and Sichale J.A. dissenting. Number 3. The basic structure of the Constitution can only be altered through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collection of views, constituent assembly debate, and ultimately a referendum. Okwengu, Katembu, and Sichale JJA dissenting. 4. Civil court proceedings can be instituted against the president or a person performing in the functions of the office of the president during their tenure of office in respect of anything done or not done contrary to the Constitution. Tuyot J.A. dissenting. 5. The president does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 6. The Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report, the BBI Steering Committee has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. 7. The Constitution of Kenya Amendment Bill 2020 is unconstitutional and a usurpation of the people's exercise of sovereign power. 8. The Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the Independent Electoral and Boundaries Commission. Sichale J.A. dissenting. Number 9. The Independent Electoral and Boundaries Commission does not have the requisite quorum for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution. Sichale J.A. dissenting. Number 10. At the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was neither legislation governing the collection, presentation, and verification of signatures, nor an adequate legal regulatory framework to govern the conduct of referenda. Sichale J.A. dissenting. Number 11, county assemblies and parliament cannot, as part of their constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill 2020 initiated through a popular initiative under Article 257 of the Constitution. Number 12, the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to predetermine the allocation of the proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Sichale J.A. dissenting. Number 13, the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral Boundaries Commission are illegal, null and void, because they were made without quorum and in violation of sections 5, 6, and 11 of the Statutory Instruments Act 2013. Sichale J.A. dissenting. And 15, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257(4) and 5 in respect of the Constitution of Kenya Amendment Bill 2020. B, we hereby set aside the following declarations and orders of the High Court. 1, that President Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 2, that Article 257(10) of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct questions, referendum questions, to the people. Nambuye, Okwengu, and Kiage JJA descending. 3, the BBI Steering Committee established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette of 10th January 2020 is an unconstitutional and unlawful entity. And lastly, the cross appeals fail and are hereby dismissed. This being a public interest matter, the parties shall bear their own costs in these appeals and in the High Court. In conclusion, on behalf of the entire bench that heard these unprecedented appeals, I wish to sincerely thank all the parties and their respective advocates for the diligent manner in which they argue these appeals and for the industry that they put in the preparation of all the useful material that was availed to the court. The authorities were so voluminous that time did not permit us to peruse and cite as many as we would have wished to. I found the submissions by all the parties quite concise and well researched, and that is our task of preparing this judgment. I also wish to thank our legal researchers and secretarial staff for their immense help in the preparation of this judgment. And with that, we come to the end. We come to the end of our delivery of the judgment in these consolidated appeals. But there is one other, 307 of 2021. I don't know whether Mr. Charles Kanjama is here. Is Mr. Charles Kanjama here? Or is anyone holding his brief?
Yes, my lord. My name is Moki.
Yes.
I appear together with Mr. Kanjama. Mr. Kanjama appears virtually.
Can I request we have order, please? Unless you have to go, just sit down so that we finish. We want to finalize in the next 10 minutes, if not less. This is the judgment of the court, and it's a short one. The genesis of this appeal is that by an application dated 16th of March 2021, Mr. Charles Kanjama, hereinafter referred to as the appellant, sought to be joined as an interested party in Nairobi High Court petition number E282 of 2020, as consolidated with 7 other constitutional petitions, which sought to challenge various aspects of the Constitution of Kenya Amendment Bill 2020. The learned judges declined to admit the appellant to the proceedings. They stated that they would give their reasons for so declining in their judgment. On 13th of May 2021, the High Court delivered a lengthy judgment in respect of the consolidated petitions, but failed or inadvertently omitted to render the reasons for declining the appellant's application for joinder. On 26th of May 2021, the appellant filed a notice of appeal and subsequently a memorandum of appeal challenging the substantive findings of the High Court. The Independent Electoral and Boundaries Commission, the appellant in civil appeal number E291 of 2021, and the Attorney General, the appellant in civil appeal number E293 of 2021, filed applications seeking to strike out the appellant's notice of appeal dated 26 May 2021, as well as the appellant's memorandum of appeal dated 8th of June 2021. Their main argument was that the appellant, having not been joined as an interested party in the consolidated petitions and having not appealed against the ruling of the High Court, could not raise in his memorandum of appeal issues that he had intended to argue before the High Court. This court, Okwengo, Kiage, and Tuyot JJA, on 28th of June 2021, issued the following orders in respect of the 2 applications. 1, I will not read all those orders. The appellant subsequently filed a memorandum of appeal dated 30th of June 2021, which contains 7 grounds. However, only the following ground was in accordance with the ruling of this court, and it was this: the learned judges erred in law by failing to give reasons in the judgment in declining to admit the appellant in the High Court proceedings pursuant to the application for joinder dated 16th March 2021. When the appeal came out for hearing, the appellant wanted to argue all the 7 grounds of appeal, but the court directed that it could only hear the appellant within the confines of its ruling of 28th of June 2021. Accordingly, it is only the aforesaid ground that was argued. On that ground, the appellant argued that the learned judges erred in law by failing to give reasons in the judgment for declining to admit him in the High Court proceedings. This ground of appeal is unassailable. The record of appeal shows that shortly after a hearing the appellant's application, the learned judges stated, and I quote, "After due consideration of the rival arguments by the parties, the application by Kanjama to be enjoined as an interested party to the consolidated petitions is hereby declined. The court will give its reasons in its full judgment." End of quote. It is a requirement that under the civil procedure rules, judgment or ruling should contain a concise statement of the case, the points for determination, the decision, and the reasons for such a decision. The object of this requirement has been explained in several authorities. Although the learned judges had given the appellant the indication that the reasons for their ruling would be given in the judgment in the consolidated petitions, no such reasons were given. Accordingly, we find that the learned judges erred in failing to give reasons for declining to admit the appellant in the High Court proceedings pursuant to his application for joinder dated 16th of March 2021. This is a case where an order remitting the matter to the High Court for the giving of reasons would have been apposite. Given the specific circumstances of this case, however, where the proceedings before the court are spent and the consequential appeals have all been heard and determined, we would be acting in futility. At any rate, no prayer to that effect was made. We say no more. We make no orders as the cause. That is the judgment of the court, signed by all 7 judges here. So with that, ladies and gentlemen, counsel and parties present and those who are following virtually, we've come to the end of our session, but I see Senior Counsel is on his feet. Senior Counsel,
yes,
take the floor.
yes. My lords, my ladies, Mr. President, let me, on behalf of the counsels, on behalf of the appellant, and probably those on behalf of the respondents, appreciate the laudatory remarks that your lordships and your ladyships have made towards the performance and the prosecution of their respective cases before your lordships and ladyships. But I, for one, in return, would want to appreciate the patience we have experienced in this rather long and complicated appeal, if I may put it that way. But at the end of the day, it is only the duty for counsels to present the cases of their respective clients and for the court to make the determination. And for that, we appreciate the judgment and would only hope that we'll be given copies of the judgment, soft and hard copies, and if possibly they could be certified. Thank you, your lordships and your ladyships.
Thank you. You shall certainly be given soft and hard copies of the same. It's fairly late now. You may get them tomorrow is Saturday. Monday is not too late. You'll get them on Monday. They are ready.
With the court's permission,
yes,
just
Senior
one
Counsel.
word, that I do concur with the sentiments of my learned colleague and senior Counsel Orengo, and we want to say thank you very much to the court for your patience.
Thank you, Senior Counsel.
May I say something, my lord?
Yes, Senior Counsel, come in.
Yes. My lord, may I sincerely thank you on behalf of my learned friends. It has been hard work. Many bulky, fat documents had to be read. Lengthy submissions were made. But my lords, we are stand most grateful to you that you have been patient and you have handed to us the best. The Constitutional Court is the Constitution of Kenya and the rule of law. May I say something that I have observed, my lord? Permit me, particularly your lordship, the president. I know this court is committed to development of jurisprudence. And during the submissions, I have noticed that each judge has had to write a judgment of his own, of his or her own. My lord, I got the impression that this develops our jurisprudence very much. There is much to be learned from what my learned Judge Sichale said as a dissenting judge, as to what my learned Judge Justice Okwengu said. We can develop the law We can develop the jurisprudence of the country if at times we do what you have done in this case, that each judge writes the judgment gives his or her own views on the matter. My lords, it is during crisis that you can see large judicial minds. This case has been a big case, and one thing that I've observed on my own is the greatness of judicial minds we have in the country. As a country, as one of the judges pointed out, we tend to criticize ourselves a lot. And at times we don't identify that which is good among us. When I was in the High Court, I was able to see some of the great judicial minds we have in the country. They are great. In this court, I have been able also to see the judicial minds that we have in the country. Some of the judicial minds, my Lord, if you may permit me to mention some of the things that some of the judicial minds have noticed, they actually do measure very favorably that we hear in the West, names like Chief Justice Marshall, names like Chief Justice Kiwanuka of Uganda, names that we have heard Lord Chief Justice Lord Justice Atkin, and even the great Constitutional Court judge in Germany. We have great judges in our country, and this is great hope for the country. Great hope in a sense that we shall have the rule of law in the country, and we shall develop our own constitutionalism. On my own, I may disclose that I have received a lot of calls from overseas, people interested to know what is going on. Kenya has scored a mark, that people are seeing that jurisprudence is emerging in this great country of ours, and all of us can be proud of it. My lords, with those few remarks, again I say to you, thank you very much. Nobody has been a winner in this case. This morning, I was really not going to come to this court because I had a past problem to attend to. But those that I asked for, the Kenya Human Rights Commission telephoned me and said, Camino, you must go to court. Kituo cha Sheria telephoned me and said, Camino, you must go to court. And what we want you to tell the court is that if the judgment is delivered against us, we want you to put in a notice of appeal immediately. I'm glad that I will go back and tell them that what happened in the court is that the Constitution of Kenya prevailed. The rule of law in the country prevailed. There has been another very happy development, my lords. I was listening to the former Attorney General Muigai talking. He said something that I thought was very impressive. He said that, look, the trouble with this case that we have of BBI is that nobody seems to agree with anybody. There is disagreement everywhere. Indeed, that has been true. We disagreed a lot in the High Court. We disagreed a lot in the Court of Appeal. But what is beautiful is that in the end, my lords, you have been able to bring us together, all of us. When we all leave this court, we shall all be smiling that justice has been done. Their lordships have been able to tell us what the law is. They have been able to interpret the Constitution to us very favorably, and in the future we can be able to refer to it in courts and elsewhere. Above all, there has also been a very happy development. I was reading in the newspaper yesterday, I think it was yesterday, the Right Honorable Prime Minister, Raila Odinga, said was to this effect, that we do not mind very much as what their lordships say. We shall be bound by a judgment, and if we are defeated, we shall proceed and continue with the campaigning. That was a very happy development. I was impressed by that statement that was coming from a statesman. And then our own president, Uhuru Kenyatta, in Mombasa, made a similar statement when he said that he was addressing BBI, and he said words along this to this effect, that I have done the best I could have done for BBI. Now, much depends on their lordships. If they deliver in our favor, well and good. If they don't, I have done the best I can. My lords, that is the way things should be. The executive, the judiciary, and some of us who are agents of the law, who are advocates, and the ordinary mwananchi who moves in the name of Wanjiko, we should all be committed to the rule of law so that we can all move forward and we shall all be beneficiaries. Thank you very much.
Thank you very much, Senior Counsel. And with those many remarks, we come to the end of this evening, this session, and the court will now rise and wish everybody good evening.